Supplementary list, fresh submission, item number 1.
On behalf of Mr. Polita, I may kindly permitted to place my
Yes, yes.
The petitioner is agreed by the inaction on the part of the opposite parties 2 and 3 in not taking any action for eviction of unauthorized encroachment of government land made by OP number 4, my lord. Your lordship, kindly see,
Where is your representation?
I made representation annexer 2 at page 9, and that was enquired by as per order of the Tahsildar, that was enquired by the revenue inspector at annexer 3 submitted report. And in the marginal order side, and the Tahsildar directed the IIC for eviction in the presence of RI, but till date, my lord, even though the order has passed annexer 3 page 10, my lord.
No, but that report says there is no obstruction and there's no encroachment.
They are encroaching the government, encroach the government land, and that is a dilapidated house in the government land, over the government land. And also they are going to construct another house in the government property. I have also enclosed the...
Right. Counsel, the petitioner states that on the petitioner's submission, an inquiry was undertaken by the revenue inspector, Biras, who has written a letter to the Tahsildar, Basudevpur, on 23/11/2021, confirming that there's a thatched house in dilapidated condition on the government land. Stop. Council now states that the encroacher is likely to raise a new construction on the said land. Paragraph. In that view of the matter, an order is issued that the Tahsildar Basudevpur will, after hearing the petitioner as well as opposite party number 4, pass appropriate orders in accordance with law. Pass an appropriate order in accordance with law, not later than 1st May 2023, and communicate the order to the parties not later than 8th May 2023. The court clarifies it as an order of question.
Item number 2.
May I please the Lords? My Lordship, this is a PIL which aims at benefiting students who have taken admission under Section 12(1)(c) of the Right to Education Act 2009. Lordship, just to give a brief background of this act, the Right to Education Act has been has created a very inclusive approach in which students belonging to disadvantaged and background classes can take admission under Section 12(1)(c). Up to 25% reservation is made for them in private schools, private unaided schools. Now, this education, free and compulsory education, they can take up to class 8 only. What the petition, in this case, the petitioner seeks to address is what happens to these students after class 8. Now, when they are joining any private school, the fees of these schools are already very high. So after class 8, they have to again spend money from their own pockets to pay for those fees.
All right.
Lordship, and from 2010 onwards, around 40,000 seats are available for these students. Every year, around 8 to 10,000 seats are filled up by students belonging to backward classes.
What is this? Has come to page 44.
The representation, my lord.
That's 22/12/22, right?
22/12/2022.
And now if you read that point 1.
Yes, my lord. 4.1. Fees and charges should be commensurate with the facilities provided by the...
No, just above that, it says as per Honorable High Court Order, serial number 18. What is that? Which is this High Court Order?
As per Honorable High Court Order, serial number 18, further parent 9
Which
and
is this
10.
High Court Order? This is our High Court or which High Court? And which order is this? Are you aware of that?
Lordship, may I take instructions on this one?
Yeah.
Because on the representation, in page 45, they have asked for extension of RT. This particular point I might not be
No,
aware.
only that if the High Court has earlier dealt with this, we should know it. That's all. It's a concept the petitioner wants to take instructions on. The
Lordship, on
single
this-
court, High Court order, unquote, referred to in the petitioner's representation dated 22/12/2022. At her request list on 29th March.
Okay.
Item number 3.
Lord, on behalf of Mr. Chittaranjan Das, I pray for adjournment, my lord.
Why?
My lord, my senior is out of station, my lord.
That's hardly a ground, sir.
Order of assessment is under challenge.
Annexures 1 and 2. So these are appealable, right?
Yes, sir.
The present petition challenges an assessment order dated 19 July 2021, which is an appealable one.
My lord,
Consequently, while permitting the petitioner to withdraw the present petition to avail the statutory remedy of an appeal, the court directs
my
that.
lord, may I pray for passover, my lord? I will inform my senior.
All right.
Appear to
Pass-
BC,
pass- all right.
my lord.
Item number 4.
May it please your lordship. The lordship, in absence of GST tribunal, the petitioner has challenged the first.
All right. Same 10%, 20%. So this time make the date as 27th March. Session 27th September. 27th September.
Item number 5.
Lordship 5, 6, and 7, same.
Yeah, same date.
Item number 8.
Item number 8, my lord. Item number 8, my lord, these are matters relating one of the GST revocation, my lord. That the time limit has lapsed, so it's been
The
covered
standard
by.
order must be there.
My lord, I filed a memo to that effect, my lord.
Or same order.
Lord,
You have to change the name of the council. Right? Name of the council has to be changed. Right.
my lord.
My lord, I have not been served. My lord, it is that revocation application he will file alone.
Yes.
Item 9.
And item 9, my lord, it's an same petitioner. Because of that medical problem that she had, she couldn't prefer an appeal. The demand under 73 was there. In between, that registration also got cancelled, my lord. My only, there's a appeal lies under 107, my lord. I'll prefer an appeal before the competent authority.
Petitioner seeks leave
My
to
lord,
withdraw the
only
present
humble
petition.
prayer, my lord. My lord, that at least they'll consider the fact that there was a medical problem.
That all you raise in the appeal. So
Well, there's a
liberty to file
order.
an appeal as provided in law. If such appeal is filed not later than 3rd April, accompanied by an application for condition of delay.
May I pray
Stating
for
the
my lord?
pendency of the present petition is the reason for the delay. Be considered according to law. The court clarifies it is not expressed anything in the matter. It is further clarified that it will be open to the petitioner to raise all pleas raised in the present petition and otherwise available to her in law before the appellate authority.
Well, at least they'll consider my matter on merits.
I
and-
hope they will, sir. I
My lord, that's one of the orders, my lord, if have been passed. And our hyper technicalities will not be resolved.
No.
If that we observe, my lord, will
No.
be of great help. And because it's a matter of medical.
Correct.
Item number 10.
May it please the Lordship. Lordship, can I have glance to Annexure 6, page 26?
Mm.
Here is a grant of on license.
Mm.
Where the government made query about 3 grounds in the letter dated 26/12. But I have complied by giving written submission under Annexure 7, satisfying all the 3 points. Now the collector has issued a notice and he is raising another point, which is other than these 3 points which has been raised by the government. But he is saying that the shop where will be open, it should be commercial building. I have applied for commercial. It is a long since pending, my lord, before the authority, development authority. He is not granting, but law says 51 says approved building plan to be filed. I have filed approved building plan.
Why are you coming the last minute like this, sir?
No,
My lord,
this is
may I
not
submit
they have
one
issued
thing?
notice on
Everything's
7th,
getting over 31st March.
no, 17th they have given the notice. 17th February. I have appeared there and I explained about everything, Lord, before the collector. Even then, Lord, he is going other than the point which has been raised by the government, Lord.
What's the point? You will get it for some 2 weeks.
Lord, Lord, she may direct the government to consider this.
No,
Because-
that collector's requirement you have to fulfill.
Yeah,
That's
yes,
it.
I have
But,
already
this is a
filed
procedure
on
and-
17th February. I have already on 17th February, I have filed
Why
everything.
so
before.
particular for these 2 weeks? Because 31st March is the date.
Yes, my lord. Because the license will be granted within the 31st. It will be considered by the government, which will be granted by before the 31st March. So, my lord, now the collector is delaying the matter knowingly. The point which was raised by the government, he is going other than the point. It cannot be.
No. After 31st March, a fresh application will have to be.
Yes,
filed.
my lord.
In fact,
You're the opposing person.
Yes, he is the objector, my lord.
Everywhere. One petitioner, another object.
It is hard, Madam Lord. He was in hard by the collector also. Government and
let me tell you, Lordship, Lord, I am a caveator here. I have not been implicated as a party, though I am a caveator. First. Secondly,
he is a public, Lord. How I know that who will file objection or will be there?
that's
And
Anyway,
here, Lord, he filed petition here and he was in withdrawn. That also have enclosed.
All right.
He has withdrawn that writ petition.
let
All
me
right.
place my words at this.
Yes.
Yes, sir. I'm saying about
The
your
problem here is, my Lord, if you see page 26,
Hmm.
there is a genuine problem that to this particular structure is coming under 440 kV electricity line.
Ah,
And under Indian electricity rules, rule 80 sub rule 3, it is prohibited. There
right.
can be no construction under a overhead high power electricity voltage.
Brit has given the
One second,
permission.
Mr. Pa- One second.
Approved building plan has been given.
One second.
So that was taken into account.
That is illegal.
After taking that.
Can-
And also, Lord, that
Anyway,
point was.
all that you have to argue before the commissioner, you're
No,
arguing.
it is already argued.
Ah.
It is already argued before the government, Lord.
Ah,
Government issued this notice. I have filed written submission and it was argued and he is not passing final order.
so you
Is to
want to
pass
take
final
instruction
order.
on when final order will
Yes.
be passed, Mr. Monty?
My lord,
Let's take instruction. When was the hearing? When did the hearing happen?
Hearing, Lord, on 10th January.
no, collector has reached.
Thereafter, collector again hearing.
He is not
How
arguing.
is the collector hearing?
How-
Yes, you tell me.
If you, my learned friend will permit, I will.
Yes, yes, I have no.
Even if again, but collector has issued another query notice and you have to
Does the
respond.
collector have the power? It's crossed him, gone to the
That
commissioner.
again, I have to take instruction that how
Take
and
instruction.
why the
Mr.
collector
Monty
has.
states that he wants to take instructions on the
From the
current
collector.
status of the application made by the petitioner. At his request list on 9th
9th March.
March.
Lord, obliged.
My lord, may I submit one thing? We are now at the fag end of this exercise year. Now daily your people are coming that my application is pending. So now at least 20 to 30 files are pending before the secretary for consideration. And 30 days time only left. And this is the.
Because, Lord, in the district level, they're
I
dealing.
think
Law says within 2 months they have to send.
2022, this
Let me
matter is going.
clarify that position. Let me clarify that position. There is already an order passed by the division bench of this honorable court. In the cases where applications are pending, has not been rejected, but because of this 31st of March,
That may
there is
also
an
carry out.
already order that those applications shall be treated to be pending.
Yes, Lord. Treated to pending and next year it will continue. That also this honorable court has held
So
also.
next date we can
Order
see
this.
that.
Yes, Lord.
All right.
Obliged.
Item number 11.
11 minutes. Now I'm in the position of Mr. Patna.
I'm not opposing here.
But since 1998, but since 1998 over this very location, there was a off-shop running.
Mm,
The licensee lost it in the last lottery.
mm.
Thereafter, he applied for the on-shop on the over the very.
So let him take instructions on this also.
But this can be disposed of by the government. Milord. They have fixed the date of hearing on 13th.
Ah.
Let that be disposed of on that date.
All right. Mr. P.K. Rathore, learned counsel, the petitioner informs the court that the matter is fixed before the secretary,
Secretary on 13th.
the revenue department, excise department, government of Orissa on 13th March 2023. So considering that the outer limit is 31st March 2023, the court directs that the matter will be heard on that day and an appropriate order should be passed within a period of 4 days thereafter.
Right.
All right. The petition is disposed of. A copy of this order be sent to the secretary, excise department.
Item number 12.
Synopsis is to file, madam.
On state ଅଛି ଏଥିରେ? State.
Yes.
Madam, the only question for discrimination, madam, under the Mohammedan law, adoption is not recognized, madam. The order passed by the respondent one under Annex 3, madam, in one part, it was hold that he is not the adopted son. In the latter part, it was hold that he is the son of Major
All
Mohammed.
this can't be gone into these proceedings, sir. There'll have to be a civil suit, I suppose, for this.
And my lord, in any case, it's a consolidation revision
Paternity,
order. was-
proving paternity and all can't happen in these proceedings.
Madam, constitutional authority should not declare the status also, my lord. That is settled position of the matter.
Your Lordship, if I may appraise this honorable court, they have, the only question is whether the person is the adopted son of Mazhar Muhammad or the natural born son of Mazhar Muhammad. In that regard, before the revenue court, we have already filed list of documents, government records, revenue records, RORs, all kinds of documents. The only basis of their claim is 1931 unregistered family settlement deed or something. Your Lordship, the thing is that document will not be admissible in any civil court. Therefore, the petitioner, in order to skirt around the law, has made the revenue court sit over the question of right title interest in this matter.
No.
Therefore, the revenue court has rightly rejected the contention, and that has been confirmed by the honorable.
So it was this objection.
Madam,
It was your objection that they decided.
madam, my contention is that there is no adoption under the Mohammedan law, madam. So the running page 43.
No. At whose instance was this commissioner's order passed?
At the instant of the respondent 3 to 6, madam.
At my instance,
No. And why did you go in revision against the consolidation officer's order?
against the consolidation officer's order, he had passed that order on basis of a 1931 unregistered family deed.
No. Which was brought by him.
Brought by him. Therefore, the honorable the
Correct.
commissioner.
So you invited this whole litigation, sir. Now you can't wriggle out of it.
Madam, the constitutional authority cannot declare a person.
You invited it. Now you're saying you can't declare. You are the one who objected, saying he's not the real son.
Adoption, madam.
You start off a litigation, and when he decides against you, you say he should not decide.
No, madam,
That's a
that
very
is-
strange argument.
Madam, that is not.
You withdraw your original objection, then all this will say. You withdraw your original objection, saying I will go to the civil court. Then we'll record all that.
Madam,
You can't have it both ways. You
Madam,
can't go before this authority, raise an objection.
But whatever
When it is decided against you, you say, no, he should not say all this.
Madam, the order which has been passed, what will be the status of the order, madam?
Therefore, you withdraw all your objections. His status will be secured. If you have to challenge his status, you go to the civil court.
Madam,
You decide. You chose a forum. That forum decided against you. Now you say that forum should not have said all this.
My lord, two things are there in this type of cases. First is adoption is unknown to Mohammedan law. Second is adoption issue can be decided by the consolidation authority, division bench decision of this honorable court, Honorable Justice R.C. Patnaik, that adoption issue can be dealt with by the consolidation authority.
I don't know.
But adoption is unknown to Mohammedan law. Mohammedan law, there is no plea of adoption.
No. So he's decided that there is no adoption here. The decision taken is that the person is the natural born son.
So has to be. Otherwise, adoption is not there in this particular Mohammedan law. There is no adoption.
No.
Hindu law.
When he raises an objection that such a course is not recognizable, but he says there is an adoption. His basic point is X is not the natural born son of Y.
Yes.
That has been decided in this consolidation.
So he's very
against him.
His very approach is erroneous.
so madam, the civil court is the only remedy. Till then, this order impugned.
You can't. This is the whole problem, sir. You raise a dispute, and now when it's against you, you say that the decision has been against.
Madam, I didn't raise the dispute. The dispute raised by them that claiming that they are the adopted beneficiary.
No, Your Lordship, the original case was filed by them. As Your Lordship.
Correct. Election. Have you heard of the doctrine of election? No. Doctrine of election. Have you heard it? You've not heard it. You want to take time to study it? Okay.
Lordship would
In
find
some
the
other case, you
maintainability
get a lot of time to study.
maintainability of this writ appeal because its 227 jurisdiction has been exercised by the honorable single
So
judge.
writ appeal is also not maintainable. So both double, you got a double attack. So you say the challenge in the present writ appeal is to an order dated 17/12/2021 passed by the Honorable Single Judge dismissing the appellant's writ petition civil 34507 of 2021. Full stop. In the said writ petition, the appellants had challenged an order dated 30th July 2021 passed by the Commissioner Consolidation and Settlement, Odisha, Bhubaneswar, in RC number 107 of 2014, allowing the revision petition filed by the respondents
3 to 6 million.
3 to 8. No, 3 to
6 million.
No, sir. It goes on till 3 to 23.
The order included, Lordship can have a grant to running page 34. The petitions are Sheikh Abdul Wahab to
Sir,
Sheikh
you
Ajaz.
come to your cost title. You
Those
come
are
to your cost title in the writ appeal.
3 to 6
3 to 6.
3 to 6 million. 3 to 6 million.
All right. Respondents 3 to 6. And holding that Sheikh Abdul Wahab, bracket respond by 3. Actually, my cost title shows in the writ appeal 3 to 24.
Because originally, common ancestor is Wazir Muhammad. He's having three
Just see
sons.
pages 54, 55.
Million.
The list of opposite parties begins at page 51, actually 50, and there are 3 to 23, 24 opposite parties. So it's not 3 to 6.
No, the claim made by
3 to 6 have filed that.
They are claiming to be
Why have you made so many parties respondents?
So Miller can have a grant to the synopsis. The original Wazir Muhammad was the common
You
ancestor.
answer my question, sir. Why have you made so many parties as opposite parties?
They were a party in the lower court, in Constitutional Authority. They made it. They made them.
All right.
In Divisional Court, they made them party.
All right. Holding that. Abdul Samad
And if
Is the-
page 34.
natural son of Mazhar Muhammad. Stop. Paragraph. The objection in that regard, claiming that he was the adopted son, was raised by these appellants in the consolidation proceedings. Full stop. The decision of the consolidation officer in their favor was reversed by the commissioner in RC number 107 of 2014. Paragraph. The learned single judge has noted how sufficient materials were placed on record before the commissioner to enable him to come to the above conclusion. To stop, the learned single judge accordingly concurred with the findings of the commissioner. Paragraph. Apart from the fact that, you say counsel the appellants submits that the appellants would now like to go before the civil court, raising a claim. Until such time the civil court decides that the findings in the consolidation proceedings against them should be kept in abeyance. Full stop. The court is unable to agree with the above submission. Stop. It is the appellants who raised the objections in the first place. and have invited orders in the consolidation proceedings which negate their contentions. Full stop. They cannot now be heard to turn around and say that the findings against them in the consolidation proceedings should not be acted upon. Paragraph. There is a second difficulty, which is that the impugned order of the single judge has been passed in a petition under Article 227 of the Constitution. Full stop. Applying the decision of the full bench of this court in Muhammad Saud versus Dr. Major Sheikh Mahfouz 2008-2 OLR bracket FV 725, which has been approved by the Supreme Court. In Muhammad Saud versus same cause title 2010-13 SEC 517. The present writ appeal is not maintainable. Full stop. Consequently, the court is not inclined to entertain the present writ appeal, both on maintainability as well as on merits. The writ appeal is accordingly dismissed.
Obliged. Item number 13.
Much obliged.
May I please, Your Lordship? So the appellant was appointed as on ad hoc basis as a peon in a government school and continued for more than 26 years. And after 2 months, she is going to retire. So she has prayed for regularization of her service. The Honorable Single Judge did not allow it with the reason that she was not appointed in an existing vacancy, which is not correct. Your Lordship can see Annexure 2.
No, this was the second round of litigation, sir.
My Lord? Yes, my Lord, it is writ appeal, my Lord.
My Lord, in the last occasion, my Lord directed
come to page 36, para 3.
My Lord.
The writ petition is dismissed on the ground that this is the second round of litigation on the self-same cause.
No,
para 3.
My Lord.
Para 3.
My Lord.
Do you dispute this?
No, 3 is the decision of regularization. It's a policy of government.
He's reading correctly.
Read it. My Lord, it has been mentioned that decision of regularization of service is a policy decision of government. The prayer of the petitioner is beyond the purview of jurisdiction of this present opposite party number 3, who has already considered her case in pursuant to order passed by this court in earlier writ petition filed by her.
So what is this a correct statement or this is an erroneous statement? Did you file an earlier writ petition?
Yes, my Lord.
So correctly tell us the facts. Therefore, when I told you that this is the second round of litigation, you should have said yes.
Yes, my Lord.
Now you're saying it after we are spending so much time drawing your attention, making you read it. What was your prayer in the first round of writ petition?
This prayer was different, but the Honorable Court directed to dispose of the representation.
What was the prayer in the first round?
Prayer for regularization, my Lord.
So how is it different? The same prayer in making the second round.
You accepted it and participated.
No, I have not accepted it.
That judgment to consider your representation, you did not accept it. Have you challenged that order?
No, we have not challenged because
you have accepted
it was not against the prayer, so we have not challenged. But the question is whether the petitioner who has continued for more than 26 years on ad hoc basis can be.
So first of all, when you argue a matter, since you're a very senior person, sir, and we are too junior to advise you.
My lord.
But normally when you argue a writ appeal, you're supposed to place the full facts correctly before the court.
Yes, my lord.
Ah.
Yes, my lord.
Ah.
My lordship can see whether they are impartial in giving such a decision by rejecting the representation, my lord. And the reason of rejecting the representation has also been repeated by the Honorable Single Judge.
Yes, what do you say?
My lord, in the last occasion, my lord directed him, if the government has formulated a scheme, to file the same, the last order. So he has not filed any scheme before this
You
order.
can tell us, sir. You're the government. You're government rule, you know?
Yes, my lord.
Ah, you tell us.
Yes.
You should know more than he knows
There
on
is
this.
no scheme, my lord. There is no scheme prepared by the education department. As far as the SME department is concerned, no scheme has been prepared.
Ah. Yes.
My lord, the question is, previously we were referring to the case of Uma Devi versus State of Karnataka and also ML Kesari versus State of Karnataka. And in our...
Unless there is a scheme, you cannot demand it as a matter of course, sir. If there is a scheme and they have not considered you under that scheme or discriminated against you, then you can make a claim.
My lord, continuance of more than 26 years on adult.
Correct.
Your lordship can decide if your lordship, the poor widow lady is going to retire after 2 months, my lord.
You don't want to argue the law then. You have to argue the law, no, sir. You have to say in law how is your claim maintainable.
My lord, ML Kesari case is applicable to this.
What is applicable, sir?
A case of ML Kesari and State of Karnataka.
Show us how it is applicable, sir. You have the judgment.
Well, in case of ML Kesari, it has been at the end of 6 months only.
Do you need time, sir? You want time to prepare?
I can read the judgment is with me.
Normally, sir, for us, it's a bit difficult in your reading and we don't have copies. And even for him, it will be difficult. We don't remember this ML Keshri by heart.
My lord,
Some difficulty we have.
My lord.
He also has a difficulty. Can you remember ML Keshri by heart, sir?
I've gone through it, but judgments are present.
You can manage, but we both cannot. We will need copies.
Your lordship can give some time to...
All right. Counsel for the appellant needs time to address arguments and prepare and address arguments at his request list on. April 26th.
Hello?
26th April. Item number 14.
May I please join? That I have challenged the order of the learned single judge, where the learned single judge by misconstruing the issue involved in the writ petition, and 3 provisions out of 2 is under the Registration Act and 1 under the Orissa Hindu Religious Endowment Act, has completely blocked my right to present the instrument for registration. But I am asked to bring in your lordship can see the impugned order.
State materialship. Copy has not been sought yet.
No.
Our office. 15. Item 15.
14, sir.
Show the copy notes.
That I cannot be debarred from presenting the document for consideration, because my lord, there is a bar under the in the amending act. Your lordship can see the Registration Act. If I have not brought the permission from the endowment authority within the, I cannot sell the property. That is the bar. It has been created under Registration Odisha Amendment Act 2013. But here is a case, it is a private DT. and we have presented the document for registration as the Marfatdars. And we have also applied to the commissioner endowment for giving the permitting us to giving the necessary permission to.
What did you do in those proceedings? You filed an application.
That proceeding, Your Lordship can see.
19A, you
98 I have filed. Lord, that is, Your Lordship can see for a movement section 19A provides of it.
All right. OHREA.
Section 19A.
Yes.
Regulation of registration of documents. Then Your Lordship can turn to the provider law. Provided further that a no objection certificate shall be deemed to have been granted if the registering officer is satisfied the transfer or having applied for grant of no objection certificate to the commissioner.
When do you apply, sir?
But I have applied, Your Lordship kindly see that proceeding. It is in the page 132. 132, I have filed the necessary application under section 19.
When?
But I have filed it on 19/2/2018.
All right. You say, Mr.
19/2/2018.
Sorry, Mr. Mr. Sahu, learned counsel to the appellant, refers to the second proviso to section 19 capital A of the Odisha Hindu Religious Endowments Act 1951, bracket OHRE Act, and states that in the present case, with the appellant having approached the commissioner with an application for grant of no objection way back on
19/2/18.
19/2/2018.
19/2/2018. There should be a deed. NOC. It should be deemed that an NOC was granted, and on that basis, the sub-registrar should have proceeded to accept the draft sale deed for registration. It's a notice. The monthly accepts notice for opposite parties 1 to 3. Notice on behalf of the Commissioner, Mr. Nath, is it?
I will take notice for the government. Mr. Nath will appear for
Nath accepts notice for opposite party.
Let him serve copy on Mr.
The remaining opposite parties by registered speed post returnable on the next date. List on
copy to the government.
30th August.
Item number 15.
May I please, Your Lordship? The petition appellant was selected by the selection committee on 25/7/1992 as no other eligible candidates was available for consideration by the selection committee. On the basis of recommendation of the selection committee, the petition appellant was appointed as a lecturer in English on 31/7/1992. My result, I have passed PG examination in the year in July 1992, but the result was published on 23 March 1993. My appointment was subject to publication of a result, and the governing body accepted the same. And after publication of a result, I submitted my certificate, and the governing body approved my appointment. Thereafter, the college in question was established and got first temporary recognition and affiliation from the session 93/94, commencing from 1/6/93. And the post was created from 1/6/93. And much prior to 1/6/93, the appellant had the requisite qualification to hold the post. After considering that the governing body recommended after 2008 granted order came into force, the governing body submitted proposal for approval of my appointment and others, and the Director of Higher Education and Government, after verification of proposal submitted by the governing body, approved my appointment under 2008 granting order, and the petitioner received block grant. As per condition mentioned in 2008 granting order, one has to complete 5 years by 1/6/2008 in order to receive grantee aid. Since the petitioner was appointed and post was created from 1/6/93 and much prior to it, the petitioner had the requisite qualification. The appellant has the requisite qualification. The appellant was approved and he received grantee aid. My lord, after so many years, suddenly the principal placed the petitioner under suspension. And as per Rule 21(2) second proviso, the competent authority is the governing body. At the initiation of disciplinary proceeding, will place the petitioner under suspension for a period of 30 days. And in case the suspension is not approved within 30 days by the director, the suspension lost its force as per division bench decision in the Navakishore case of this honorable court. The petitioner challenged the suspension order passed by this honorable court, passed by the principal who is incompetent authority before this honorable court.
How did this whole trigger? Who made a complaint that he had not submitted your mark sheet? Somebody? It says an inquiry was after receiving allegation from different quarters.
My lord,
the regional director verified the records. That he found out that you had not submitted your postgraduate mark sheet.
My lord, in paragraph 6 and 7, honorable single judge held that there is no pleading, neither party, that the regional director verified and on the verification of his report, on the basis of his report.
No, but this is 30 years after you joined.
My lord.
This is 30 years after you joined.
My lord. I am verge of retirement and I am continuing on suspension seat without any subsistence allowance since last more than 8 months.
And no inquiry.
No inquiry. They have not submitted any, supplied any documents. Which document I submitted at the time of?
For 30 years. Who raked up this not supplying mark sheet? Who raked it up? There's a complaint made against you.
One person made complaint against me behind my back. And without considering the principal since my colleagues, he placed me under suspension. We had joined in the same day because of seniority, even as in charge principal, and without governing body approval.
Oh, so yes, that same person has placed you under suspension.
Suspension. I challenged the suspension before this honorable court. This honorable court directed a consideration.
All right, you just say notice. This is school and mass education or which department? Sir, just look into this. It can't be so arbitrary. After 30 years, somebody gives one complaint and he's placed under suspension.
I'll file counter, my lord.
Lordship, I am filing miscase. I have not paid a single pay subsistence allowance, my lord.
All right. Take that miscase on record and say counsel for he accepts notice for 1 and 2, notice to 3 and 4, by registered speed post returnable on the next date. Paragraph, learned counsel for the appellant informs the court. This IA to be numbered. In this IA, say, learned counsel for the appellant informs the court that since the date he was placed under suspension, that is 10th May 2022, the petitioner has not been paid any subsistence allowance and has also not been furnished with any charges.
Not supplied the documents, even the charges.
Not supplied any documents in support of the charge sheet.
My lord, besides the charge sheet was issued by the principal.
Whatever, sir. According to him, no inquiry is also commenced. Has also commenced. You see, list on. You better have them served immediately, sir.
My lord.
List on 4th April. 4th April.
Notice to a private opposite party.
Yes. Yeah. Registered speech post tracking report in the paper.
My lord, I am sorry to mention, my lord. Since my grandmother expert item 68, I'll go to my native place, my lord. Lordship kindly adjourn 68 item.
All right. Let's make a note.
Just
all right.
Item number 16.
This matter was dismissed. I mean, on virtual mode, my lord. The matter was dismissed on the ground of non-appearance of the lawyer, madam. Because lawyer could not know the matter was listed on the same date.
No. Mr. Mishra, you should know more than anyone else. This will not work, Mr. Mishra.
And they simply restored the matter, and then your Lordship may.
No, sir.
The non-appearance of the lawyer will be a cast on us, that will be.
What is the client properly aware of why the lawyer did not appear? The client is obviously not told. He's not told the truth, sir. That's the problem. The client has not been told the truth. Unfortunately, the court knows the truth.
Bow down for Lordship, now the time has changed, madam.
It
Now
should,
the
sir.
time
It
has
should.
changed. The lawyers.
So, I want the lawyers to at least tender an apology. That's the least. And undertake not to commit such an act in the future. That's the least. That's the least that the court expects.
I do that, madam.
So at the request of Mr. Mishra. And you don't have to tender it to me, sir. You tender it to my successor. All right. List on 14th August 2023. Mr. Mishra undertakes that the lawyer will file his own affidavit explaining correctly the reasons for his absence and tendering an apology to the court. All right.
Item number 17.
Item 17 pertains to my lord's appointment of member to the OHRC that has, my lord, been complied with. Yes.
My lord, the member has been appointed, but one grievance I have.
No, who has been appointed?
Mr. Asim Amitabh Das has been appointed as member.
Mr. Asim Amitabh Das as member and Justice Pujari as the chairman. Now it is already complete.
It's a two-member commission, isn't it?
No, three-member.
Justice Raghuvir Das is already there.
No, he has tendered designation, my lord.
That has not been accepted.
Yes.
That has not been accepted.
But my lord, I have one grievance. These litigations are recurring. Earlier also there was a round of litigation.
We can anticipate future litigations.
No, sir. Earlier also there was
This is one of those rare commissions which has got full membership.
No, my lord, I have another grievance. Because even if in the statute there is no limit to fill up the vacancies, the Honorable Supreme Court in 2005, I have these judgments, my lord.
What is your grievance today?
DK Basu judgment.
No, what is your grievance today?
So far as this case is concerned,
this case is concerned.
You want the commission to be
it is filled up.
Then that's the end of the matter.
My lord, one thing I want to mention in public interest, my lord, that if the Supreme Court has laid down, then if any vacancy arises, it shall be filled up as expeditiously as possible, but not later than 3 months. This should be adhered by the state government so that there will be no litigation.
Next time, see, Mr. Das, you are very alert. Next time you have got their dates of retirement with you in your pocket.
Yes.
So you 3 months before the date of retirement, if you find out they have not moved the file another petition.
Yes.
Before the
correct
vacancy.
Yes.
You say the court is informed that the chairperson and member of the Orissa Human Rights Commission stand appointed, and even the resignation of the third member has not been accepted. Full stop. In effect, therefore, as of today, the OHRC has no vacancy. Full stop. That view of the matter, no further directions are called for in the present petition. It is disposed of. It has served its purpose, so
yes,
they should be happy.
I'm grateful.
Rather, I would say that because of this PIL only, the government has expedited, and
yes, I am obliged.
All credit goes to Mr. Das.
Obliged.
All right. Yes.
Item number 18.
Yes.
Please, my lords.
Yes.
Lordships, the writ petition is in the nature of PIL, my lords.
Yes.
Challenging the illegal encroachment of the encroachers in the helipad area near Bhogarai block, my lords.
Right.
My lords, the actual size of the land was initially was about 10 acres, my lords. My lords, we have filed this spot map and the Khatan wide annexure 2 and 3, my lords. My lords, it was originally it was around 10 acres. After this encroachment and all, it has gradually shrunk to 3 acres, my lords. And this encroachment is evident, my lords. It has been published in the local newspaper. This petitioner, this Sangha is
Bogra is Senior Citizens
Yes,
Forum.
Manas. It is a senior citizen
All
forum, Manas.
All right, all right. You
Manas,
say
we
the
have filed a
petitioner's-
representation.
Yes. The petitioner's representation shall be examined by the RDC.
Yes, Manas. Whereas opposite party
Should it
to
be
RDC
RDC or
Cutter.
collector?
RDC.
Collector.
Collector or
By the collector.
collector.
Collector. And after, where
No,
are
it
the
is
encroachers?
eviction. Tahsildar is the appropriate authority.
And where are the encroachers, sir? Not name them.
No, we have not
You
named.
should not. You should name them, no? So you want to file a fresh representation? Do that. Yes, the petitioner seeks to withdraw the present petition with liberty to file a fresh representation, naming the encroachers, and after following up on such a representation, to seek appropriate orders in accordance with law. Deeply.
Item number 19.
May I please, Lordship? Here the petitioner are inhabitant of Pratap Sassan Gram Panchayat received from reliable information that the opposite party number 3 going to issue a sand quarry in the river bank of river Bhargavi, for which the Gram Panchayat will be highly affected with pollution, traffic jam and Balakati Bazar, my lord, for which they have filed a representation before
That representation, where is the
That
proof of
different is but your lordship may see there is no proof at all prima facie to show that these things are going on or we are planning to give. Only by saying that the comment is on anticipation, he has filed this writ petition. If there is any advertisement, he can challenge it. There is no advertisement yet.
Only reliable information.
Reliable information, how can you maintain a
Mr. Counsel, the petitioner seeks to withdraw the present writ petition with liberty to file a proper representation as and when the cause of action actually arises. And after following up on such a representation, to seek appropriate remedies in accordance with law. Disposed of withdrawn, liberty is paid.
Item number 20.
Yes, Mr.
So this is the only sole prayer. The public drain comes for the sanctioned since 2019 has not been completed. So the petitioner is continuing representing to all the authorities. But his grievance has not.
Where is the proof of that?
Yes, proof is that your lordship see that is page 13. That is that CDO video and also CDO Jila Parishad, and thereafter lordship see 14.
These authorities don't have stamps and all, is it? They simply write on the side.
Yes, my lord, stamp is also there. And also your lordship see 14 communication.
Where
the
is
order your lordship video by the chief
Page 13, top left. CDO from EO. Top left.
And also in the video, everything, all the that is the communicated interdepartment the communication also.
All right.
From
the petitioner's representation shall be examined by the BDO
review
Reguna Balashwar district, and after hearing the petitioner, an appropriate order shall be passed not later than 1st May and communicated the petitioner within a week thereafter. The court clarifies it is not expressed in the All right.
Item number 21.
May please, my lord, this is a writ petition in nature of PIL. The petitioner has challenged the bid number GEM 2023 B230829885 dated 4/2/2023. My lord, may kindly have a grant.
I know that bid must have been accepted, sir.
That apart, Rule 8 has not been complied. They have not made any representation to the authority before filing of this PIL.
How are you connected? How are you affected, sir?
I am a public spirited person, my lord. May kindly have a glance to run.
No. Public spirit is all fine. How are you worried about this?
2,000 computers has to be purchased, but the quality which has been prescribed that are not the proper quality. My lord, may kindly have a glance to running page 29, last paragraph, above the last paragraph. Further, if any seller has any objection, grievance against these additional clauses or otherwise on any aspect of this bid, they can raise their representation against the same by using representation window provided in the bid details filed in seller dashboard after logging.
Are you a seller?
No, I am not a seller.
Then why are you reading?
Sellers has raised objection running page 34 and onwards.
Why are they not coming forward? Why are they firing up from your shoulder? Why are they firing from your shoulder, sir?
No, myself, I am a social worker also and a lawyer who works for the betterment of the district of Jaspur. That's why I have come from because 2,000 computers has to be purchased, but the objection raised by the sellers from running page 34 onwards, they have categorically stated.
Ask the sellers to come and object. Counsel for the petitioner states that certain sellers had raised objections to the bid submitted by whom?
By the OP number 3, my lord. District project office.
No, this is an objection to him.
My lord.
You're objecting to the conditions clauses in
my lord, conditions clauses.
So that how can he be entitled
certain clauses? I have objected to certain clauses in the bid documents.
Neither he is a participant to the bid.
It is not clear why the petitioner would want to come forward when the sellers themselves, who are supposed to have the grievance, have not come forward. Full stop. Consequently, the court is not satisfied that the present petition is bona fide and calls for interference. The petition is accordingly dismissed.
Item 22.
Published.
May I please your lordship? My lord, questions of law at page 34, my lord. Small a, my lord, paragraph. Whether on the facts and the...
So why is this, why do you make the tribunal a party? I have never understood that. It's the tribunal's order that you will be challenging, correct?
My lord.
It should be actually only the commissioner of sales tax or somebody like that. What's the question of law?
Commissioner has been challenged. My lord, opposite party number 2.
I know, but my lord, tribunal itself a party is a bit strange. Anyway.
My lord. My lord, question A. Whether on the facts and the circumstances of the case, the learned tribunal is justified in vacating the first appellate order and sustaining the levy of tax on tobacco, which is contrary to entry 73/116, part 2 schedule B read with explanation thereto. My lord, second question is whether on the facts and the circumstances of the case, the learned Odisha Sales Tax Tribunal committed grave error of law in resting onus on the petitioner, especially when the audit assessment framed under section 42, by order dated 25/7/2007, taking into consideration observations made in the tax audit under section 41 was reopened by the successor in office in the garb of exercise of power under section 43 on a change of opinion. My lord, third question is whether on the facts and the circumstances of the case, tobacco sold to the manufacturer of BD fell within scope of entry 73/116, part 2 of schedule B read with explanation thereto. Your lordships may kindly come to page 14, my lord. Page 14, my lord. That the position...
nobody appeared for the SSC. You saw that impugned order?
Yes, ma'am.
So you're saying at least virtual hearing should have been given because of pandemic.
He has chosen to file a written note, and in the written note, he has not asked for any personal hearing.
But that normally happens in second appeal.
My lord, remanded to the tribunal for... Tribunal has not considered these aspects of the matter, my lord.
His written note has been taken.
Tribunal has not considered my
points taken in his written note has been dealt with.
I see. Actually, very.
Explanation restricts dual taxes not be due to rental agreement between.
Let him appear.
On merits, let him.
All right.
You say it is seen from the present revision petition by the SSC arises from an order dated 21st September 2021 passed by the Orissa Sales Tax allowing the department's SA number 129-5/2012-13, which in turn was filed against an order dated 27 July 2012 by the DCST appeal Sambalpur range, allowing the appeal filed by the SSC. Paragraph. From the impugned order, admit the following question of law is framed. Should the appellant be given another chance to appear before the tribunal and place its case on merits, considering the circumstances explained in the memorandum of appeal? Question mark. Paragraph. From a perusal of the impugned order, it is seen that none appeared for the SSC when the second appeal was taken up for hearing by the tribunal. Paragraph. In the present petition, the SSC explains that the hearing took place during the COVID-19 pandemic period, and the petitioner's authorized representative was unable to remain present when the appeal was taken up. Full stop. Although written submissions were filed on behalf of the SSC and were taken note of by the tribunal, the fact remains that there was no personal hearing of the AR of the SSC. Paragraph. Considering that the hearing happened during the prevalence of the COVID-19 pandemic, the court has reviewed that a more lenient view has to be taken of the inability expressed by the counsel for the SSC to appear before the tribunal on the appointed date. Full stop. Further, the issue involved regarding the applicability of the you see, the question whether sale of tobacco to manufacturers of BDs would fall within the ambit of entry 116, read with explanation to Part 2, Schedule B of the OAT Act, required to be examined in some depth with the assistance of counsel for the SSC. Full stop. For the aforementioned reasons, the question framed is answered in the affirmative in favor of the SSC and against the department. The impugned order of the tribunal is set aside, and SA number 129-5/2012-13 is restored to the file of the tribunal to be once again considered on merits after hearing the parties. The appeal will be listed before the tribunal on 17th April 2023, on which date the petitioner SSC would appear through an authorized representative. Stop. Both parties will cooperate with the tribunal. We are able to dispose of the second appeal as expeditiously as possible. The petition is disposed of in the above terms.
Obliged. Item number 23.
May please, I will kindly grant 1 week time. I will remove the defect.
Defects be removed. You see, list on 29th March, defects be removed in the meanwhile.
Obliged.
Item number 24.
4 minutes. Brief has been transferred. Minutes. I don't know. Somebody.
Counsel, the petition informs the court the brief has been withdrawn. None appears for the petitioner. Dismissal of prosecution.
Item 25.
My lord, item number 25 is an application challenging the order of the Joint Commissioner State Tax in confirming the order of the learned proper officer in for the period of mismatch of June of 2019. I'll serve the copy actually.
Sir, copy has not been served to opposite party number 5 also.
So same, you deposited 10%.
So it's a Red Tech versus Joint Commissioner of State Tax.
No, it's against the first appeal order, right?
Yes, sir.
So same thing.
So we have already deposited 10%.
Same order. All right. List on.
10%.
27 September.
Sir, aspiring for opposite party number 5 the copy.
Item 26.
Impugned is order is under Annex 2. It is passed by the first appellate authority on the Western Justice.
Same, 27 September. All right.
Item 27.
27, I have removed the defects, my lords. It's in absence of the tribunal, my lord. I have already deposited, my lords.
All right.
Here, my lord, the interest portion has to be stayed, my lords. The entire demand is relating to interest because the entire tax has been paid.
All right. So, counsel, the petitioner informs the court that the entire tax demanded has been paid. In that view of the matter, there will be no coercive steps taken against the petitioner to recover the interest on the tax amount during the pendency of the present petitions. The IAs are disposed of.
28 and 29, same, my lords.
Yeah. So
I have a very humble prayer. This WPC 5306 of the same petitioner for another period, my lord, involving the same question.
Taken on board and same order.
5306 of 2023.
All right. 5306 also.
Obliged.
List on 26 September.
The Lordship, I am appearing for opposite party number 2, 3, 4 for all these 3 appeals.
All right.
4.
All right. One were there. Right.
Item number 30.
The 30, Lord, last week I have received the counter. Lord, I will file rejoinder.
All right. Rejoinder will file for
this matter also connected to item 64. Lord, here the opposite part, the item 64, OP number 5 is appearing. Lord, I am permitted to also serve the copy because I have not filed requisites. I'll serve because same opposite party, I'll serve copy to him.
Both the matter be tagged together, my lord, and that may be fixed.
All right. Both tagged together.
The private respondent file karcha, counter file karcha.
No. Private respondent, I think, 64. 64. That is a Kotak case.
Right.
30, 64.
30 and 31.
And 64. 64.
30 and 64.
64, I am appearing for the OP number 5, the licensee, my lord.
I'll serve, my lord.
My sub has shifted and has made functional since 1st July 2022.
Item 31.
Item 31 is not covered by Lordship's order. On Monday, Lordship passed.
I have filed a caveat petition and he
Lordship directed to consider the objections by the collector Jashpur.
He is the off-sub licensee, my lord. I have applied for on-sub. He is objecting me, which is 2 kilometers distance from my sub, my lord. It's no right.
Let their application, my objection may be considered.
Same order.
Yes.
Item 32.
32, my lord. My lord, kindly turn to page 12, my lord. Here the government had taken a decision, page 12, last paragraph, my lord. Consequently, collector advised to fix the MGQ of the individual licensee for the year 2023 taking into account of MGQ prescribed for the licensee as per excise policy of 2022 and 23 along with short drawn MGQ quota for the year 21-22 if any. My grievance is that, my lord, the government has already taken a decision for the previous year during the closure.
My lord, may I submit one thing? These are all policy decisions. Previous that we will carry forward the MGQ for the next. This year, what will happen, nobody knows. We are going to declare the policy. And before that, he is filing a petition that government should be directed. So far as policy matter is concerned, I humbly pray your lordship that there should not be any.
My lord, I pray.
How can you insist that we will do something? That is a decision of the state government whether we will carry forward or we will issue demand notice. That depends upon the last year. That is because of COVID situation, etc. We have taken the decision. Whether this year the same decision will be taken or not, that is yet to be. This is a premature petition. Your lordship may not issue notice even. That is my humble prayer to your lordship.
Saying for issue notice, my lord, I humbly pray. I will file a representation before the government.
That represent on your representation, this is a decision to be taken for the entire state. All the vendors, you are only one.
I have genuinely.
I'm sure you get similar representations. You must have already got. I think Annexure 16 is one such representation.
Yes, my lord.
I will file a fresh representation, my lord.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation to the government regarding waiver of MGQ.
No, my lord.
Waiver of short lifting.
They don't say waiver of him. They say that it's
Waiver of short lifting. Yeah. Waiver of short lifting of MGQ for 2021-22. Dispose of his withdrawn liberty is paid for.
My lord, may I pray one thing to your lordship? Your lordship may record my statement that this is a policy decision of the state government which is yet to be taken.
So you inform him when you reply to his representation, you can say that.
Yes, ma'am.
Yes.
Item 33.
May I please your lordship? This is for the second time the petitioner has approached your lordship. Lord, the petitioner as well as the OP number 5, they both submitted application for onshore in the same locality, only having 50-meter distance from each other. The petitioner's application was not substantially proceeded by the district excise office. I approached your lordship, where my lord was pleased to direct that Annexure 4 your lordship's earlier order, the district excise Baleswar should recommend the case of the petitioner to the excise commissioner by 22nd February of this year, and accordingly the excise commissioner shall also forward the application to government by 1st March, by today, my lord. On basis of your lordship's direction, there was a hearing. Lordship may see the Annexure 6, page 24.
Yes.
On lordship's order, the hearing was conducted. Lordship can kindly come to the operating portion, 27, last paragraph. Page 27, my lord.
Yes.
On hearing into the matter, as stated in the petition, the Honorable Court, the Collector and District Magistrate Baleswar rejected the proposal on the specific ground stated below. One is Shiva temple was 457 meters, inhabitants of SC community 364. The decision has been made in obedience to violation of Rule 26 or Odisha 27. Then lordship came to next page. Why I approach your lordship, this is the result I have got, my lord. Therefore, the including here of the following documents for non-consideration of new proposal of grant IMF of my lord. And it has been forwarded to the commissioner, my lord. Lordship, 26 empowers state government to relax any restrictive position, my lord. That position stipulated on B and C. Here the collector has no jurisdiction to reject my application at the threshold. He has to recommend with some way. Lordship, whereas the same inspector, my lord, he submitted in inquiry report in respect of OP number 5. He have never shown that there is a SC community at the same distance, my lord. Lordship may see his inquiry report. The inquiry report made in favor of the OP number 5. Lordship, I have annexed that. Same collector has recommended and he has issued with a license that Annexure 7 is page 29.
Lord, if my client is implicated as a party there.
You only implicated so, my lord, his application was substantially proceeded and he has got the license. Same on basis of, say, the inquiry report by the same officer, my lord. In his inquiry report, nothing has shown there is a much restriction as he violates complete Rule 26. He has given the license in the meantime.
Let him serve me a copy. I'll take instruction and appeal.
Now, Olifra, yesterday they have sent the file to the government, my lord. Let government decide taking all facts, my lord.
My lord, this is the
Because
case
31st
where
is
I
approaching.
find the collector has rejected the proposal. Commissioner has, on the basis of that rejection proposal, has forwarded the government. Then how you can say that because the Honorable High Court has directed them,
Because
Honorable High Court has never directed
in
them
every
to pass a positive order.
Lordship knows in every recommendation, if there is some violation of Rule 26, so collector recommends
No,
for
it is a
relaxation. But
subjective-
here the
subjective
they say the non-consideration. He could have simply forwarded file. These are the restrictive provisions. For the OP number 5, same restrictions he has considered and recommended, and he has got the license. So only that there is a disparity, my lord. Same distance, only 50-meter distance.
You want to take instructions anyway?
Yes.
All right.
Plus, fix a short date.
Notice, Mr. Ratha accepts notice for respond to 5. Monty for opposite parties 1 to 4. Both of them seek time for instructions. Reply, if any, to the petition be filed within 4 weeks joined of the next date. What is the time period and all?
31st, my lord, March.
31st March.
No, not 31st. Lord.
The only difficulty is that, my lord, because the rule says within 2 months.
Matter is pending.
They delayed about 6 months. Whereas the district of SI is shown favoritism to the OP number 5 and his application was forwarded.
Incorrect allegations. If the government is session on the matter, then he should approach the government. Let
So
the
I
government
think
take
that, my
a
lord,
decision.
it will be
I think it's
better
very
if the matter remitted to the government. So let him consider taking into all aspects, whatever the amendments I have made in the writ petition, let it be examined by the government.
That is better. What Mr. Das is saying, your
prayer
lordship.
clause.
My lord,
Prayer is to grant license.
Prayer license cannot be granted by the Honorable High
Consider-
Court. Your lordship may direct the secretary to consider the proposal, taking into consideration the
all aspects.
the collector's view and pass necessary orders within
Before
March,
31st.
Before 31st. That will suffice everything.
Okay, let's take off that. Say, given the limited nature of the prayer made in the present petition, a direction is issued to the Principal Secretary, Excise Department, Orissa. So considers the petitioner's application for on-shop license in terms of Rule 51 of the Orissa Excise Rules 2017 and pass a reasoned order not later than
31st March, my lord.
Before 31st March.
All right. Not later than 20th March, we'll say.
Yes,
20th
20,
March.
that may be 25th March.
All right.
25th ହେଇଯିବ
25th March
28.
Obliged.
That would.
No further directions are called for. A copy of this order be sent to the Secretary,
Yes.
Principal Secretary,
Yes.
Excise Department, Government of Orissa.
Obliged.
And taking into account the view of the collector.
Collector, my lord, this is the always, my lord.
Item 34.
In 34, my lord, I am the cavator.
Yes, I am for the petitioner. I think the cavator wants to take a lead, Vilas. But the petitioner, Vilas, in this case, challenges Vilas the recommendation Vilas made by the excise commissioner to the government Vilas in respect of a proposal for grant of Vilas this on-shop restaurant license on the proposal of opposite party number 6 Vilas, who is a defaulter of government area revenue for the immediately preceding excise year 2021-22. And that is a debacle, that's an impediment under Rule 35 of the excise rules. 1. 2, he has shown an affidavit given along with the application which is required under Rule 51 of the excise rules, saying that he has obtained no due certificate. Because my specific averment is because in the interest of revenue also I allege that the affidavit is a wrong, false affidavit. He is in arrears, and your lordship will find I have also annexed affidavit application. Page 52, there is a manipulation of sale register for the purpose of avoiding MGQ liability loss. Your lordship will they have enhanced the sale figure, and that list is of the excise department at page 52. 1, 2 bills. So far, the distance criteria is concerned, your lordship knows 26 Rule 26 bills, which are very specific for the purpose of considering and weighing the merit of the application proposal bills.
No, you're for the opposite party.
I am the now the
Opposite party
person whose
6.
paper license has been issued, my lord.
Right.
Because in
No, it has not been issued till today.
In response to your lordship's earlier order passed in a PIL, Lordship specifically directed the principal secretary to hear the matter and giving to opportunity to all the opposite parties, my lord, or the objectionists, my lord. Accordingly, the hearing was conducted. An inquiry report was also sought from the ADC, Barampur. On 24th February, the order was passed in my favor. Explicitly, that has been decided.
Anyway,
In
that's
this
what
case.
is challenging, sir. He's challenging that precisely.
Yes, my lord.
Ah,
A copy may be served one so that.
Yes, I will serve a copy.
All right, you see notice return 26 September. He accepts notice for opposite party number 6. Mr.
Opposite number 6, yes.
Yes. No, Mr. Mohanty accepts notice for 1, 2. 1 to 5. Reply be filed within 8 weeks adjourned of the next day.
But so my instruction is a license has not been granted, my lords. State need to take instruction. What OP number
According
6
to
is
Mr.
claiming.
Saul, learned senior counsel for the petitioner, license has still not been formally granted to opposite party number 5.
Yes.
If that be so,
He must be knowing.
Jannath, you are telling the court that
this is the order.
no, you just now told the court that you have got the license. I'm sorry to say this. What my friend
February,
is
the order was passed by the government.
So a decision may kindly await till the till decision of courts. Without leave of the court, no license be granted.
No, in that event, the entire pendency will be of no
Because
meaning.
this
because you lose revenue.
Yes, yes, my lord.
Then if my learned senior wants that, the Lordship may direct the secretary to consider his objection and pass necessary order before
Yes, he was very much present. The Quran saw with the ex-sarpanch of that area.
No, what else?
And because this PIL is
by Pinky, some Pinky Behera.
earlier was Pinky Behera. But this time is a Quran Swai, he's the ex-sarpanch of that area.
I think in the state's interest, my friend should within a limited time grant us file a reply, because what collector once has given report bills, there cannot be a roundabout turn once again to give another report bills with a different fact. That is what has happened in this case. So many things like that you may not reply orally, bills.
No.
Interest also
Keeping this matter pending beyond March will solve nobody's purpose.
That is whose 8 months they have taken. No, your state has taken 8 months.
Just a minute.
Public notice is June 2022.
Just a minute.
June 2022.
Because it has to end by 31st March.
Nothing to be attributable to this petitioner or anybody. So now it has been taken 8 months. So the court is not responsible.
This PIL is at instance of another offsop, my lord.
And already there has been.
Anyway, they need time to decide. Correct?
Yes, minutes. Let them take notice. In a short time, they may file reply.
Within 10 days, we will file reply.
Yes.
Your Lordship may fix it
Reply
to
within a week.
Yes.
Adjourned up for the next day. Based on
15th March.
All right, 15th March.
Yes. No final decision in the meantime.
No. That
otherwise,
is not. In no case, your Lordship is passing any agreement.
He
should notice.
If no decision has yet been taken on the issue of license, no such decision shall be taken till the next date.
Deeply obliged.
Lordship may direct to sub a copy of it.
Item 35.
None appears to see some.
Item number 36.
Item number 36, orthopedic case matter. All the similar matter, my lord. All the cases are similar matter, except one matter, my lord. The last item, WA 94 of 2001. That is the different, my lord. In this, respondent already appeared. The last item, WA 94 of 2021. That's the last one.
Who's appearing for the other side? So we'll send it back. No. This is the very first thing. He's appearing. Appeals. They've all been served. No. This order will apply only in 36 item, sub item 1, is it? Whom are you appearing for, sir?
Yes, my lord.
Whom are you appearing?
I'm the private party affected.
In which matter?
Your number?
94 of 2021.
94 of 2021.
So 94 of 2021.
My main case was WPC
No, we can pass an order in this
16656.
and then to be followed in others. So in 94, he applies for the respondent, then this order will be passed. Same order.
In this regard, there is a contempt file 1561 by 2021.
What about the remaining items? 8th May. Then there are some 10 more matters will get it. Every day we take on 10 more matters. March. All right.
Item number 37, please.
There's a strict appeal. That's the first day disposal. My lord, the impute order is at page 47.
All right. We'll send it back, sir.
Only one thing. If you also look at the document, the judgments, and citing my associate is there. If you also can look at the judgment. 75 cases were disposed of, titled Jatin Kumar Das. Then, madam, the division bench allowed the tribunal's judgment, confirmed the tribunal's judgment. If you also look at page 1, serial number 6, madam. It is Subrajit Misra.
No, what difference, sir? On the very first day, it was disposed of, the writ petition.
Well, same order passed in respect of DOA. Same order, same order was passed. A batch of matters disposed of. In respect of DO, they have framed the rule on 14/2/2023. From out of the same
He
judgment,
was not working as a DO, he was a junior programmer. There is a difference, and
let them explain it, sir. They'll explain before the single judge. Same order, same dates. All right. Contempt case, you see list before the single judge. As per the roster. On 20th March. No, sorry, on the contempt April.
Item number 38.
May I please, sir? The impugn order is at page 51.
Who's for the other side?
My lord, in item 38, my lord, I am for the respondent. In item 38, my lord, I am for the respondent, my lord. And the order has been implemented by the authority, my lord, after my retirement, my lord.
All right.
My lord, here, my lord, the direction was to send his CCR for consideration of his promotion because the direct collector sought for CCR. That was not sent. That is why I prayed before. And Lord Singhal was directed to send his CCRs. That was the order, my lord. But they sent my CCR after my retirement by way of implementation of the order.
Not my case, he is a state cadre employee. The promotion he wants, that is a district cadre. He cannot be considered against that post, even if that in respect of state cadre, that's a different issue.
I was retired on 30th November. They sent it CCR on 9/2/23, madam, by way of implementation of order of the.
What do you say?
That has not been implemented.
How do you know? He's showing you the order, sir.
I'll take instruction.
Counsel to the respondent informs report that the impugn order challenged by the state in the present appeal has already been implemented. The relevant document has been shared.
After my retirement, they sent my CCR.
Who states that he needs time for instructions. List on. March. 28th March.
39.
Same.
39 wale you'll also fix it to 13th March because similar matters have been fixed.
All right, 39.
The only difficulty in this, I have the instruction to appear on behalf of the opposite party, my lord. The only difficulty is that the respondent is working but not paid his salary since October 2021.
The first day disposal.
Yes, it's not a first day disposal, my lord.
First,
Initially, my lord,
no, my lord, it's not a first day disposal. Subsequently, it was remanded thereafter this has been disposed of at the administration. Annexure 1. We have approached my lords that the first day disposal. Thereafter, this order was passed, relying the judgment passed in another case that is under challenge in WA number 777 of 2021, which is fixed to 14th March. My lords may turn to page 31A, annexure 5.
14 March.
14, but in the meantime, let them take instruction as to the regarding the salary of the opposite party. The opposite party has not been paid his salary despite working.
The counsel for the respondent alleges that the respondent has not been paid his salary since
October 2020, my lords.
October 2020. Mr. Kutia states that he will seek instructions on this aspect as well. 13 March.
Grateful, my lords.
Item number 40.
Nana, please.
Lords may turn to page 46. The impugned order.
Page
46, my lord. 46.
Yes.
Annexure 2. Only question arises for consideration, my lord. At the time of his appointment, though he had that VSC qualification, he was appointed in a particular scale of pay. He filed a case after 20 years of his appointment.
We dealt with some similar issue, I thought, the other day.
No, my lord, this is the first case. Anyway, after 20 years of his appointment, he claims that since the scale of pay attached to the VSC post is different, he is entitled to that post. That scale he is entitled. Admitted fact, my lord, on the date of appointment, he had that VSC qualification.
Similar question that we've dealt with, sir. Anyway, is a notice. No one appearing on the other side. Notice returnable.
My lord, I have the instruction to appear for the private opposite party, my lord.
40. I'll serve. And he has filed a contempt petition, your lord's may stay.
Notice, he accepts notice. List for panel hearing on. August 31st. In the meanwhile, no further proceedings will take place in the company. Which contempt case, sir? It's not listed.
Contempt is 5477 of 2022.
No further proceedings will take place in contempt case number 5744 of 22.
5477 of 2022, my.
Right, 5477 of 22. Got it.
Item 41.
May I please, your lordship? Lord, by annexure 5, the honorable single judge has disposed of the writ petition, holding that it is not maintainable, which is completely perverse and erroneous. Your lordship may kindly see, by annexure 3, my lord, the commissioner consolidation disposed of the application filed by the present opposite party number 1, declaring his right title interest, and directed the consolidation officer to carry out the order by recording his name. Accordingly, by the annexure 3, the consular officer only carried out that, no adjudication. So, against order under section 37(1), only writ petition is maintained, no appeal is maintainable. But your lordship may kindly see annexure 5, my lord. And furthermore, before the commissioner, the present opposite petitioner, appellant before lordship, was not a party. It is a government of Orissa undertaking. It was not made a party. Before the commissioner, the Tahsildar representing state was the party, whereas state is no way involved in the suit led. Your Lordship, may I kindly see annexure 5, my lord. Page 36.
This is an Article 227 petition, right?
My lord.
Single judge?
My lord.
This petition has been disposed of invoking Article 227 of the
226, 227, writ of certiorari, my lord.
227.
My lord. Not 226 and 227, not 227.
It is 227, sir. This is proceeding arising under the Consolidation of Holdings Act.
Yes, consolidation of prevention of fragment of land.
So that is an order under 227, sir, not 226.
My lord, my application was under Article 226 and 227. And it was a writ petition, my lord. It is not a civil miscellaneous petition under Article 227. So, my lord, this honorable court has held in several cases against the order, writ petition is maintainable. And accordingly, several writ petition is being filed. And it is entertained. My lord, then your lordship may grant me some time, I will submit a decision.
Are you aware of the full bench decision?
My lord, yes. By Justice Naidu, my lord. Yes, Naidu. I am conscious, my lord.
Achha.
Yes. Chief Justice, Justice L. Mahapatra and S. Naidu.
Why will that not apply?
My submission is because that would have been applicable had the consolidation is a civil court. Here, he is a quasi-judicial authority. Commissioner consolidation is a quasi-judicial authority. And my first submission is, my lord, before the commissioner, I was not made a party, though my land is being taken away.
That's a different thing altogether, sir. What jurisdiction was the single judge exercising? That is the question.
My submission is under Article 226 or 227.
No, if it is
writ of certiorari. Not power of supervision, my lord, under Article 227. Then your lordship may grant some time, I will give certain decision that writ appeal is maintainable.
No, this 37(1) is a revisional power, correct?
My lord?
37(1) is revisional power.
Yes, so much power, not revisional like 36. 36 is the revisional power. 37(1) is the somoto power. That has been exercised in my absence without making me a party. And the land of the
not being made a party is a different issue. If this is 227, no writ appeal lies. That's the point being made.
But I will satisfy your lordship sometime with citations that writ appeal is maintainable. It is a case under Article 226.
Seeks time to address the court on the maintainability of the present appeal. Add his request list on. Tenth August.
Item 42.
May I please, let's not turn to page 38. If the impugned order, similar order has been passed and your lordship has fixed it to 13th September. I have given.
May I please, your lordship, I am not respondent, my lord. The delayed appeal has been filed when the second contempt is pending, my lord. And your lordship's order on delayed. After filing thorough hearing, my lord, counter, rejoinder, everything, my lord, this is the pension matter. Para 9 of the judgment is very clear that the similar benefits being given to others in identical matter after confirmation by the Honorable Appeals Court.
Similar matters
and they have implemented it, and on basing upon that order has passed.
List on 14th September, interim order continue.
And since the contempt is that, stay up.
There shall be further stay of contempt proceedings.
Public.
Till the next date.
Item 43.
43, my lords, 48 days delay in filing the appeal, my lords.
Carry on.
My lords. Lords, I filed the application for condonation of delay.
So here, my lords. Move on, sir. After delay, move on. Move on to the merits.
Yes, your lords. Yes, your lords. Now, my lords, the impugned order, my lords, has been passed without giving opportunity and without giving bring the elders of the deceased opposite parties on record, my lords.
So my first ground is that, my lords, it is violates the principles of natural justice, my lords. Now, my lords, during the pendency of the writ petition, my lords, the opposite party number 2 and 3, they are dead. Opposite party number 1 also dead, my lords. Now, my lords, substitution application was filed for our opposite party number 1, but no steps was taken against the opposite party number 2 and 3. Lords, even 1 also, the substitution application has not been decided, and
All
the
right.
LRs were not.
All right, sir. Notice. He accepts notice for opposite respondents 2 to 4. Notice to responder 1 and 5 to 8 were registered speed post returnable on the next date. In the next date, the impugned order shall remain stayed. List on 26 September.
Lords, I pray for stay of the impugned order, my lords.
Item 44.
My lord, in item 44, I have already filed my okladna for respondent number 1, my lord. Well, they have not served a copy of us, my lord.
Is it the first day?
No, no, my, this
No, my lord, this
hearing,
is
my
a
lord,
judgment, my lord.
passed, and a contempt petition has been filed, and they have in contempt, that direction has been given to comply the order by end of this month, my lord.
All right, notice that he enters appearance on behalf of the respondent, complete set of papers be served on him. Interim order to continue.
The first, my lord,
The first hearing, is it? First notice, he accepts notice. What is the delay?
that 82 days.
111. 111.
All right, anyway. Till the next date of hearing, the impugned order shall remain stayed. 26 September.
Obliged. Item number 45.
May I please your lordship? My lord, the writ appeal has been filed by the School and Mass Education Department against the judgment of the learned single judge. My lord, the learned single judge, my lord, by the order dated 14/10/2022, my lord, was the order of rejection and directed to issue appointment order retrospectively and notional benefit be granted, and also that entire exercise shall be completed within a period of 1 month, and all the financial benefits shall be given within that 30 days manner. This is the order of the learned single judge. Now the matter is relating to the recruitment procedure. My lord, the process of the case is like this, my lord. And advertisement, my lord, there is 2 provisions. One is there is a age has been fixed 32 years, and another thing, my lord, he must have the employment registration card at the time of cut-off date, filing application before the authority.
All right. Which is
That is 2
all right,
grounds.
sir. All right. Notice returnable 26 September. Till the next date, there shall be a stay of the impugned order.
Item 46.
My lord, stay, my lord, my lord.
Item 46.
46 paper next week, my lord. Paper next week, my lord.
Why?
No, last occasion, lordship has directed to me to find out the clause, the registration of SSG under FSSIA Act, my lord. I am not finding out. Paper next week, I have already saw this clause. Last occasion, 9/2, my lord.
Transfer the appellant seeks some more time. Produce a copy of the policy at his request as a last opportunity. List on 27 June.
Item 47.
My lord, here in this case, appellant wife challenged the ex parte decree of divorce granted in favor of the respondent husband and without any permanent alimony. And the subsequent development is that respondent have already remarried and having a children. So the question remains to be decided regarding the permanent alimony for the appellant wife and the son. And this is the calculation, and as per the document submitted by the respondent, that he is a account manager and having different source of income and landed property. Accordingly, this is the calculation and the dowry articles given by the appellant and the son who is now 9 years old. So she is getting income from his profession because he has a trading in share, also getting the monthly salary of 60,000 and landed property from where he is also getting 30,000, 20,000 per month. Accordingly, monthly income comes to total 1,10,000. And as per the settled principle of law, 1/4 of the income.
Willing to go in for a settlement, mediation.
Mediation because he has already remarried.
On this alimony, sir.
Yes, yes.
You want to go in for mediation to settle the alimony amount.
Your Lordship may kindly.
Both of you can go to the mediation center.
Mediation has already been made with the two parties. I said,
No.
Lordship, the order dated 27/01/20, Your Lordship may kindly have a glance.
Yes.
I'm reading out the same.
27?
27/01/20, 20. Due to the pendency of the case by the intervention of this honorable court, the matter was settled with the two parties in the presence of the lawyers. Pursuant to the order, the third paragraph of order dated 27/01/20. See, the parties are appearing in person and their counsels are present. Let the law and counsel for the respective parties and the appellant number 1 as well as responded sit together today and discuss regarding the quantum permanent alimony and regarding future of the only son who was born out of the wedlock of the appellant number 1 and responded and his education. Let the counsel for the respective parties inform this court regarding the aforesaid discussion at 4 p.m. 4 o'clock. The matter will be taken over at 4 p.m. today. Thereafter, learned counsel for the respondent submitted that the respondent is ready and willing to pay a sum of rupees 5 lakhs in 2 equal installments as permanent alimony to the respondents. Let the respondent deposit 5 lakhs in 2 equal installments, and the first installment shall be paid by the end of February 20. The first installment, shall
simply your submission, sir. He has not agreed to this. This court simply, as a token measure, is asked you to deposit 5 lakhs. That's it.
My
the court did not accept your submission that this is the permanent alimony amount.
My submission before your lordship is that pursuant to the order of direction of this honorable court, a settlement has been arrived at between the two parties.
When?
And accordingly,
where is the settlement?
Accordingly, it was decided.
I'm asking you a question. Where is that settlement? Show me the settlement.
What the settlement or whatever settlement was arrived, that was submitted before the honorable court.
No.
The
order doesn't say that, sir.
Accordingly,
the order doesn't say parties have settled their disputes and it has been agreed that this is the permanent alimony amount.
The first portion of the order shows both the parties were directed to sit together.
It says let the council sit together.
Yes, my lord. And pursuant to that, they sat together and a discussion was made regarding the quantum amount.
But let's see what the later order says. Just see that.
Later order only
says that you are ready and willing to pay.
That is only.
The appellant has agreed.
That was
this is not a settlement, sir. This is not a settlement. Anyway, I'll record the fact that you're not willing to go in for mediation. I can record if you want, because I asked you, are you willing to go for mediation? According to you, you're not willing to go.
Let me take my client.
Counsel for the parties seek time to take instructions from their respective clients whether they will be willing to go in for mediation to settle the permanent alimony amount at their request list on 29th March or 28th March. All right.
Item number 48.
May I please your lordship, my lord, with 48. I am appearing for the opposite party number 5, Barampur Municipal Corporation, my lord. So last date I have filed counter affidavit, but inadvertently it is mentioned that counter affidavit has been filed by opposite party number 6. So that may kindly be corrected, my lord.
It is opposite party number 5 filed counter.
My lord.
I am filing it.
And my friend has filed rejoinder affidavit, but I have not received the copy of that rejoinder.
I have not yet filed rejoinder.
But it is noting his rejoinder affidavit.
Your counter affidavit.
I am for opinion number 5.
I have filed counter affidavit. In my counter affidavit, they filed rejoinder. Pursuant to your lordship direction, now OP number 6, the newly added BM's compulsory corporation, they have filed a counter affidavit, your lordship.
All right. OP number 6 is also filed counter affidavit now.
I mean, it is 6.
Mr. Mahapatra, appearing for the petitioner, seeks and is granted time to file rejoinder before the next date.
Can I logically ascertain the position of the Jodashaya as of now? I can see some photographs, your lordship.
That my lords have seen. Thereafter, my lords required. I filed a rejoinder. My lords may give me 7 days time.
I'm just giving the photographs, your lordship, of the Jodashaya. Delete heat subsequently addition the point. This is the as on date position of the Jodashaya, the tank.
But this can be revived.
My lordship?
This can be revived.
My lordship,
Yes, ma'am. That is the law, my lord.
Your lordship.
That is a private pond. That is a private pond.
Well, that is the law, my lord. So far that Municipal Corporation Act is concerned, I refer to section 4.
It comes under municipality.
No, not on municipality. About the
I refer to the counter affidavit filed by the municipality, your lordship. Doesn't come under the municipality. It's a private pond.
I think my learned friend was not there on last date. That is what my lord, I think he is not able to appreciate it. My lord directed to specifically serve notice to the municipality to file an affidavit under which provision the conversion is permitted. Whether municipality can convert it or not, whether municipality can have a direction.
Municipality
that order.
I'm filing a rejoinder matters in course of
municipality cannot. Only the Tahsildar, Barampur, he can convert my.
No, it's not a case of that nature.
No, your lordship. No, your lordship. It is a private pond, my lord. And your lordship may see, my lord, that has to be vested by the government, my lord. Your lordship may see 268 Municipal Corporation Act. The government has to pass an order vesting their property on the corporation, my lord.
Is it a public land or a private land?
It's a private land.
I think, my lord,
it's a private land.
Permit me to clarify the position. This is a private pond owned by private. We don't dispute that. The only judgment of our High Court is that referring to 3 number of Supreme Court decisions, the pond should be maintained as it is unless and until it is permitted. Just a minute.
Only for conduct this.
And allow me to submit, my lords. Kindly, please allow me to submit. I am not standing in the fact remains, my lords. That is what my lords directed the municipal corporation. What are the provision to show that if there is a conversion and permission to be granted or not? Because under OLR Act, Section 8A of the OLR Act, this conversion cannot be permitted. So without conversion, they cannot convert the land from pond to, my lords, any other use. That is what, my lords, require the municipality
party. My lord.
Just a minute. Now, my lords, kind of a glass provision about the private pond, how what municipal corporation can do. There, my lords, kindly refer to Municipal Corporation Act, my lords, Section 461. I want to file a rejoinder so that I could have brought all these things for proper application.
Rejoinder to be filed before the next date. All right. List on 22nd June.
Interim order to continue.
Interim order to continue. All right.
Item 49.
Yes, my lord, these matters pertain to blood bank matters, my lord, not test.
My lord, yesterday the affidavit has been filed by the commissioner cum secretary. I'll serve copy on Mr. Agarwal and also to Mr. Das. Lordship. That is e-filed and physically also I have filed today.
Lordship had directed it should be done in a phased manner starting within 3 months. But the affidavit is completely confusing, so to say. Whether they will do it or not do it, they say both the things. They say it's very costly and cost should not come
in the way. This
good. Affidavit leads to nowhere.
If my
all right, the affidavit of the state would have been filed yesterday, is it?
Yes, sir. Yes, ma'am.
Be brought in record.
Copy has been served on Mr. Agarwal. Only I have to serve on Mr. Das.
All right. What do you say? You have a copy?
Hard copy. It is e-filed, but hard copy. I'm just supplying the hard copies. Close.
Copy
Para 7 and 8, maybe.
Page 7, annexure R/1. This is the minutes of the meeting which was held pursuant to your lordship's order. And these are the decisions taken.
This is the process which will be involved in establishing the address from the application.
Oh, I'm sorry. The Puruna
I think this is a typographical error. This para a technical committee meeting is scheduled to be held on 28/2/22. It says must be 23.
No, let's have 23.
No, what happened at that meeting?
That meeting
Yesterday.
minutes I have to, that minutes I have not received. Yesterday it was, that is typographical mistake.
No, but the timeline is not there still. This entire affidavit. You see, the whole thing is
Para
just see
17.
the order.
Para 17 may kindly be seen.
To
Therefore,
file a specific affidavit for opening of such NAT testing labs in a phased manner, beginning with the next 3 months and completing it within a year. So where is that time? That timeline is not indicated. You have to say in the next 3 months, how many NAT testing labs will be opened? It is not possible to start the above project throughout the state within a year. Why not?
No, it's not complete. It's not possible to complete.
No. Just see the minutes, page 8 of this affidavit, para 2.
Para 17.
No. Page 8, this minutes. You
Minutes.
include minutes of 3rd January. Internal page 8 of this affidavit. Considering the view of the members of the committee has opined that it will not be possible to take up the project for opening NAT testing labs within the next 3 months. Why?
That is to be read as complete.
No.
Start the above project throughout the state within a year.
Let it take. Not take up. Then you should say within what time will you do it?
And Lord,
There's no time limit at all, sir.
Yes, time limit is not.
You say the court has perused the minutes of the meeting held on 3rd January 2023. regarding expansion of the NAT facilities at other blood centers of the state in the state of Odisha. In para 2 of the said minutes, it is stated that open quotation, it will not be possible to take up project for opening of NAT testing labs within next 3 months, unquote. While the minutes negatively notes what cannot be done, it fails to positively state what can be done. Full stop. The court would like to impress upon the state government that it is necessary to have a positive frame of mind, or we can say to have a positive approach in the matter and indicate in positive terms how many such NAT testing labs can in fact be commenced at the shortest possible time, indicating clearly the time frame. Full stop. The statement that open quotation, it shall not be possible to start the above project throughout the state within a year, unquote, is also not acceptable to the court. Full stop. Clearly a time frame, or you say full stop, a time frame for how many such works can be started and within what time will it be completed should be indicated in the affidavit. Full stop. In other words, the court is not interested in knowing what cannot be done, but in knowing what can be done. Really, I can't understand the language of this.
May I submit one thing?
There has
Your
to
Lordship
be,
may not record my submission.
bureaucracy.
Here the perhaps there is
elaborate exercise to tell the court what cannot be done.
No, here perhaps the word start should be substituted by complete.
Then you better advise them.
No,
you will read
your
what
Lordship
you
may
have
not record my submission.
It's if you have to read something into it, it's not some statute. You have to read
That is correct. That is
you
correct.
better tell them.
We'll file better affidavit.
A better affidavit now be filed within 4 weeks. List on May. Sorry, 1st.
My lord, in the first petition, there is also a case for compensation to the HIV victim.
Yeah, we'll take it up step by step, sir.
Item number 50.
No. You need to tell us what you cannot do. You will.
Item number 50.
I am for the Bhubaneswar Development Authority.
Yes.
I filed the counter.
Not received the copy.
Application. So the petitioner, they sought for matters demolition of the structures. So earlier, another writ application was there that minors are already disposed of. Whether any other litigation is pending, my learned friend is appearing for the private opposite party whose structure is to be demolished.
No, who's for the petitioner?
Petitioners, no one appears, minors.
My lord, fact remains, my lord. The land was over which the temple is constructed by the annexure C by 5. The plan is approved since 1975. But in the ongoing settlement, the area is reduced. And it is recorded in favor of the government, for which we have filed revision under section 15. And
where is your affidavit, sir? You have to file an affidavit disclosing present status of pending suits.
Pending suits means that my learned friend has given that affidavit and disclosed all this.
Which is that affidavit?
The counter affidavit.
My lord, I have said by not number, page 4 of my counter affidavit, point 6.6, paragraph 6.6. I have stated towards last that I have filed revisions. That is pending before the member board of revenue.
No, even now.
Yes, my lord, yes. It takes years together, my lord.
So far, what about
And so regarding suit, my lord, I have not given the number, page 6, paragraph 10 towards bottom.
So
Regarding this,
even in para 6.6, you've not given any numbers.
my revision number has not been furnished, but I have said I have filed revision.
Here, my lord, so BDA has not been made parties in those.
But
BDA is
because the
concerned-
land is in favor of the government, only government is premier party.
Anyway, he said none appears to the petitioner. Dismissed for non-prosecution. All right.
Item 51.
Made plea, your lordship. My lords, I may be permitted. My lord, this is a matter, my lords, where the petition has been filed for upgradation of differently able children's school, especially schools at Noapada. My lords, lordship may kindly appreciate. In 2017, they have admitted they are in a process of upgrading. In 2022,
One minute, sir. Let me ask you.
As the proposal is pending, my lords, I've got instruction that it is pending with the department because the proposal has been sent and it is pending. If my lords gives a month's time, we will.
Last time the same thing was said.
Yes, my lords, we had filed an affidavit on 13th of December. That was the last affidavit.
No, after which 16 December it was taken up.
Yes, my lords, it was taken up and my lords had given time till 1st of March.
The SSEPD department was to pass the appropriate order by today.
Well, so this particular school, Millers, the proposal is still pending. So
then it's in disobedience of the order. Have you got the copy of the order? 16/12/2022.
Yes, the order.
Read the order, sir. Read the order.
Millers, the order unfortunately is not uploaded. That's on the website.
Not at all. Just check
because thereafter.
One minute. Let's take it out right. And are you not supposed to apply for this order and pass it on to your client?
No, Millers, we have informed Millers that the client has
just informed, not given a copy of the order.
No, Millers,
why? Orders are not uploaded. No, 16 December. This is the last order. No, but the correcting order is at 3rd January. That is uploaded. 16 December is not uploaded. How is this possible? I say? A specific direction had been issued on 16 December that the proposal should be processed and an appropriate order should be passed by the SSEPD department by today. That is 1st March 2023. A copy of the order was asked to be sent. Where is that? The sending for compliance. Where is that? There must be a noting in the file for that. Ask for an explanation if they're not done. Was it delivered? The file noting shows that on 9th January 2023, the said order was sent to the Secretary SSEPD department with the correction made by the order dated 3rd January 2023. Paragraph. Today, Mr. Ishwar Mohanty, learned counsel appearing for the state, seeks some more time. Full stop. There is therefore a clear disobedience. Prima facie disobedience of the order passed by this court on 16/12/2022. Paragraph. A notice will be sent to the Secretary SSEPD department to file an explanation why the order passed by this court on 16/12/2022 has not been complied with. Full stop. An affidavit will be personally filed by the Secretary SSEPD department on or before 27th March 2023. It will be the responsibility of the registry to ensure that today's order is communicated forthwith to the Secretary SSEPD department, and a report of such order actually being communicated, delivered will be placed on record. Paragraph. Mr. Mohanty is directed to ensure that he not merely communicates today's order, but actually sends a copy of today's order to the Secretary SSCPD Department for compliance. Paragraph. The court will take a very serious view of the matter if the non-compliance continues on the next date. Full stop. List on. Sir, I think you're still not serious about our orders.
No.
I'm sorry to say. The secretaries are also not serious. Don't compel us to pass orders which you find very difficult.
Because this will be compliant.
29th March.
Extremely sorry.
I'm so obliged.
29th March.
Item number 52.
May I please? Here in compliance of my lord's order dated 17/10/2022. I have filed
52
additional two compliance affidavits of the Home Department as well as on behalf of the Fisheries Department. That affidavit of the Home Department filed by IG of Police is at flag 29. That has been filed by one Subodh Kumar Malik, Additional Superintendent of Police Headquarters.
Flag 29.
Flag 29. Well, there we have stated about the steps taken for filling of the post of SI of police as well as constables for steps. Paragraph 3. It starts from paragraph 3 to 7. In paragraph 3, we have stated about recruitment of 143 sub-inspectors for the year 2018, and they have joined the service on 28/12. And for the year 2019, 47 SIs have joined on 5/1/2013. And for the year 2021, 477 SIs have been selected. Advertisement have been issued and the process of selection is continuing, but the same has been held up because this Honorable Court, another division which has granted interim order not to proceed with the selection. That interim order is available at page 7 of the affidavit.
That's okay. That's only for SI.
Yes. 477 for the year 2021. Then so far as on the basis of promotion for 2023, nominations have been invited and same will be completed. And in paragraph 4, we have stated about the filling of the post of ASIs. ASI posts are filled up by promotion from the feeder ranks of Odisha Police. Regular steps are being taken to fill up the vacancies in the rank of ASI Police by giving promotion every year. The number of vacancies filled up
now,
in the
Marine police stations, you should have at least those other people you have recruited, sir. You have completed according to this affidavit.
Yes.
You've completed recruitment of SI. You've done recruitment of
ASI for 2021, 2020, 2021 and 2022 also. For the current year,
no, what about constables?
Constables in paragraph 6, we have stated.
That is written exam must have been held day before yesterday.
Yes, 26th it was there.
All right. An affidavit dated 23rd February 2023 has been filed by the additional SP State Police Headquarters, setting out the details of recruitment undertaken for the posts of SI, ASI and constables. Full stop. It is stated in alia that vacancies in the different marine police stations will be filled up. after completion of the entire process by April 2023. So which is the other affidavit? This is
Flag 30 is the affidavit by the director, fisheries. There also in paragraph 3, we have stated that the
transponders.
Yes, transponder. Now the ISRO has, you know, in paragraph 5, the director special project ISRO Bangalore by letter dated 13/9/2020 clarified that GSAT-6 satellite is meant for the use of strategic users for their communication purposes. Since the two-way MSS communication system for sub-20 m fishing vessels is part of the national security, fishermen safety, ISRO is willing to allocate bandwidth from its share to the state government to roll out vessel tracking system network upon receiving the requirement. Further, it was clarified by ISRO that state government should provide necessary transponders, network, infrastructure, and bandwidth to the fishermen for BTS functioning, and no band allocation could be made by ISRO to any individual fisherman directly. And they have said that they will allot to the state government, and in turn, state government will allot those machines.
Is there any alternative to this instead of transponders?
No, in fact,
only now your problem is again the cost. They are not willing to pay the cost at para 6.
Now that is not the problem. After receipt of the ISRO's letter, we have requested the government, central government, to modify the guideline, that is a PMMSY guideline, so that we can provide those devices to the individual fishermen, because there is a restriction. That restriction, my lord, may kindly see, is the letter, page 12, you also can see it starts from page 9, sorry, page 7. The letter of the Government of India to the state government, page 9, relevant portion is page 12. Serial 25.
Flag 25.
No, running page, no, same flag 30. It starts from annexure A, it starts from page 7.
Right.
Relevant is page 12.
Okay.
You also can say top. Heading is, you also can see serial number, name of activity, category, unit cost, total project cost, central share, state share, beneficiary share. Now, my lord, we can see 25, serial 25. That is relating to the communication and tracking devices for traditional and motorized vessels like VHF, sensor, transponders, etc. You can see there the total project cost has been provided, the central share is there, state share is there, and the beneficiary share is there in order to provide the message. Now, the ISRO has said, no, beneficiary will not come in the middle. But it is the requirement of the central government. The beneficiary has to give certain amount in order to avail the money. Accordingly, we have requested the Government of India to modify this condition so that we can provide the devices to the individual fishermen.
How the money comes, that is never an issue. That never ISRO has prohibited. ISRO has said, we will allocate to the state government, you give it to the individual fishermen.
Now,
who pays for it? That is
no,
never
state will provide under a scheme, that is PMSO scheme. But this scheme provide that the beneficiary has to contribute something. Unless that is modified, so that is creating hindrance. So accordingly, we have requested the central government to modify. And we have also requested for 3 months more time to take a final decision.
An affidavit has been filed by the Joint Director bracket Coastal Directorate of Fisheries, Government of Orissa, stating inter alia that the Government of India has been requested to modify the guidelines regarding
paragraph 7
providing tracking devices to traditional and motorized fishing vessels, tracking devices, including transponders, for traditional and motorized vehicles, fishing vessels, full stop. It is stated that the response of the Government of India is awaited.
Paragraph 7, we have stated the Government of India has agreed, but no written communication.
3 more months' time is accordingly sought for coming up with the modalities for procurement of transponders. Paragraph. The court directs notice to issue to the Joint Secretary (Marine) Government of India to file a response in relation to the above issue before the next date. The court expects the necessary amendments to the guidelines to be issued by then. Mr. Padi, learned DSGI, who is appearing in the matter, accepts notice on behalf of the Joint Secretary (Marine) and agrees to communicate today's order to the said officer. Forthwith, Joint Secretary Marine, Government of India, Ministry of Fisheries, Animal Husbandry and Dairying. For the necessary compliance, communicated for necessary. List on.
Another affidavit we have filed on behalf of the DFO Puri Wildlife Division.
22nd June.
Another affidavit we have also filed that is available at flag 28.
Right.
On behalf of the DFO Puri Wildlife Division. Right. The steps taken for protection of the olive redless for the year 2020.
Make it 23rd July. Oh, 23rd is Friday. What about 26th? I think 26th June. 26th June.
My lord, may I pray, my lord, that let them serve the copy of this and what they have filed.
Yes, I'll serve.
Right. Copy of the above affidavit be served on Mr. Padi today. This what is the third affidavit you said?
That is another affidavit of the on behalf of the Puri Wildlife Division. Flag 28. There we have stated whatever steps have been taken for the year 23 to protect the olive redless, which they have arrived now for breeding season.
Correct.
And we have also seized certain trawlers also.
Yeah, the court has also perused the affidavit dated in February 2023, filed by the Divisional Forest, by the Assistant Conservator of Forests, Puri Wildlife Division, setting out the steps taken for conservation and preservation of these strategic locations for safe nesting of the olive ridley turtles for the current year. That's it.
My lord is fixing to 26 June, man.
Yes, that's right.
26 June.
Special bench. He'll join online or? Oh.
So 8, my lord. Order dated 28/6/2019, passed by the Honorable Single Judge in writ petition number 17090 of 2012, dismissing the writ petition, my lord. Thereafter, my lord, last occasion, I have sought one judgment, my lord, that is reported in 74/1992, CLT 350, my lord.
Correct.
Wherein, my lord,
Correct.
promissory estoppel would be applied if the fact of failure was not within the knowledge of the petitioner, my lord. In that case, my lord, Honorable Justice rendered that judgment. Just I am placing the relevant persons of that judgment, my lord. Right. I am handing over the judgments, my lord.
Which one? The
It's already scanned anyway.
Justice A. Prasad and K.C. Jagdev Rao.
Nrsimhacharan Panda, na?
My lord.
This is the judgment you are talking about, the Nrsimhacharan Panda.
My lord. Nrsimhacharan Panda.
No, yeah.
That's why we're sitting at a larger bench, sir.
My lord.
We're sitting as a larger bench because you're
in the meantime, what
the
has
correctness of that
my
decision.
lord, in the meantime, what has happened, my lord, there is a full bench judgment also of this honorable court, my lord.
On the same issue.
Whether promissory estoppel will apply.
No, promissory estoppel is a difference, sir. On this, the facts.
Educational exam certificate.
Academic matter. Academic matter. Yes, my lord.
No, similar the certificate issue.
My lord.
Acha?
1992.
Promissory estoppel. Examination result declared shows that petitioner has passed, but shortly thereafter, the announcement was cancelled. To apply the principle of promissory estoppel, one has to show that he has changed or altered his position. Meaning of change explained. Alter is synonymous to change. Mere application for job or registration with employment exchange would not amount to change or alteration of position. That is para 5 to 10, my lord. My place, my lord.
Yes.
I am placing from para 5, my lord. Insofar as the promissory estoppel is concerned, in Rajkishore's case, the same was held applicable by stating at page 191 that the university having represented to the petitioners that they had passed and the petitioners having changed their position on the basis of such representation, the university is precluded by the rules of estoppel from acting otherwise in derogation to the representation made earlier. Though a submission was advanced on behalf of the university that the time lag between the two notifications was small, in as much as the cancellation came within about a fortnight. It was held that by itself did not take the matter out of the ambit of application of the rule of estoppel, particularly when even within that period the petitioners has taken steps on the basis of representation that they had passed. Now the steps the petitioner had taken in Rajkishore's case were that some of the petitioners had, after obtaining their mark sheets, applied for admission for higher study, while others had registered themselves with the employment exchange in search of service. These steps taken within a short period of a fortnight after the publication of the result were held.
No, come to para 10. Para 10.
My lord. Because of the above, we are of the view that public interest and equity demand that the doctrine of promissory estoppel should not be extended to that extent where cancellation of the result would not be permitted by the courts virtually in any case, which would be the effect if the ratio of Rajkishore case is upheld. This apart, it may be remembered that principle of promissory estoppel is available only where the person concerned has changed or altered his position, taking of steps like application of admission in higher course, or seeking of job or registration in the employment exchange would not amount to change or alteration of position. We therefore hold that Rajkishore case was not correctly decided.
So this again goes against you then.
But in the instant case, my lord.
No. So this is the whole point.
My lord.
This actually goes against you. Mere fact that you may have got a job doesn't mean they've altered your position.
And para 17, my lords. I would like to place para 17. In support of legal position that if the concerned person has knowledge about the true state of affairs, principle of promissory estoppel will not apply. Our attention is invited to a number of bench decisions of this court, the first of which is Suresh Chandra Chaudhary versus Baharampur University, report and so and so. In that case, the bench principally relied on the decision of the Supreme Court in Chaganlal, Keshwalal, Mehta versus Patel Narendra Hariwal, AIR 1982 Supreme Court 121, in which one of the requirements of estoppel was said to be that the person concerned must show that he was not aware of the true state of things or that he had no means to know the same. In Suresh Chandra, the applicability of the doctrine of estoppel was rejected because the petitioner could have known on the basis of the mark sheet supplied to him, relying on which admission to higher class was taken, that he had failed in the examination in question. Therefore, as the petitioner had means of knowing that he had not succeeded in examination and had indeed failed, it was held that university was not estoppel from declaring subsequent that the petitioner had failed. The ratio of this decision has been applied in so and so case. We have no hesitation at all in accepting the aforesaid proposition of law as if a person knows or has means to know the correct state of affairs, there can be no question of his acting on anybody's representation that a particular state is correct, though it is not so.
So just let's come to the facts of your case.
My lord, I am coming to my the facts of my case.
So you failed both in English and in education.
My lord.
But you chose to reappear only in English.
Yes, my lord.
Come to page 20.
Knowledge also.
Come
it
to
was
page
not
23.
the knowledge of the petitioner. It's my case, my lord, because the principal had also no knowledge about this particular.
No. You knew how much marks you got in education. In fact, you're not denying that.
No, I cannot deny that.
So
I have
once you know that this is the marks you got in education, you know whether you failed or you passed. Where's the question of not knowing that? Just come to page 23, bottom.
My lord.
In fact, you can start with 22, bottom.
22 bottom line. Mr. B. Das, learned counsel for the opposite parties number 1 and 2, on the other hand, contended that the petitioner, knowing fully well that she has not passed in English as well as education subjects, only choose to appear in subject English as a compartmental candidate. But so far as education subject is concerned, she did not appear. And admittedly, she had secured 80 marks out of 200 in the subject education. And as per the regulation, at least she should have secured 45 marks in paper 1 and paper 2 to pass in the said subject. That is 30% of the total mark. That is 150 and 50 is the total mark for practical. But she only secured 42 marks in education. Thereby, she has not passed in the subject education in the CHSC examination 1996. Even if the petitioner has acquired higher qualification, that itself cannot entitle her to get the original CHSC certificate, as she has not passed in the subject education in the annual CHSC examination 1996. Considering the...
So these marks were known to you. See, this is not the question of you're not knowing these marks.
And you know the pass mark. When you know the mark, you know the pass mark also. So when you know the pass mark, so it is in your knowledge that you have failed. How can you say I didn't know?
Because the regulations, my lord, so far as the regulations issued by the CHSC is concerned, my lord, there should be the applicant should not have been permitted to sit in one examination, but that is English.
No.
If she has failed in two subjects, my lord.
No. Suppose the candidate applies only for one exam to apply. How can the candidate be prevented?
You have applied for compartmental.
Yeah.
So each subject open to you for appearance. So you have chosen only English subject to be.
In view of the fact that it was not within the knowledge of the petitioner, my lord. It was not within the knowledge of the petitioner, and I have also filed another document, your lordship may kindly bear with, my lord. I have also filed one document, your lordship may kindly bear with, my lord.
Yes.
That is, my lord.
No, the question of you now being declared as pass and for us to issue a mandamus to the universities that declare him pass does not arise at all, sir. Where's the question? Once the guidelines clearly tell you that this does not amount to a pass, you cannot imagine that you've passed. How can you imagine yourself to have passed? There's no question of imagining. One can understand if it's that borderline case, where you get, let's say 50 is the qualifying mark, you got 49, and you are not aware that 50 is the qualifying and 49 means fail. Here you get only 30% marks. In any exam, nobody can mistake 30% to be a pass mark.
In view of
never. Nowhere, I don't think anywhere in any part of the world, 30% will be considered pass mark.
And in another judgment of this honorable court, my lord, the honorable single judge has
The most important thing, whether it was in your knowledge or not in your knowledge. That's the only test. This is one test.
My lord.
It was in your knowledge or not in your knowledge?
Not. It was not within the knowledge of the
No, you can't say. When mark sheet was available to you,
principal allowed the applicant to sit in one examination.
Taken as a ground, sir. See, once you know that this is the pass percentage of mark and you have not secured that mark, then matter ends.
My humble submission before your lordship should be, my lord.
See, in English, you got 35 out of 200.
My lord.
And you knew you failed.
She got 80 marks in education. She was in a bona fide belief that she achieved 40%. My lord.
Point. That's the whole point.
And the principal also was on the view on page 12, my lord. Page 12.
But doesn't mean that you should.
My lord, may kindly see page 12, my lord. Turning page 12 of your lordship's brief, my lord. Annex 4. This is the letter issued by the principal, my lord, himself. Certified that Kumari Litu Manjari Pradhan.
Page 34.
Page 12, my lord.
All right.
Certified that Kumari Litu Manjari Pradhan, daughter of Oitha Pradhan, was a regular student of our institution for the session 94 to 1996. She completed her +2 final examination second HS 1996 and was placed in compartmental division bearing roll number so and so, register number so and so. She has been issued CLC from our college on 2997 for higher studies. Unfortunately, we have not yet received her board certificate, which was to be issued from CHSC till date.
The current this also should have put you on alert.
The principal himself also does not know.
This should put you on alert that something is wrong.
That is just a applied.
Even now, if you want to do the, I don't know if the time for compartmental law is over.
Honorable Single Judge.
Compartment.
Honorable.
Necessity of allowing the petitioner to appear in the exam.
That is there, my lord. Honorable Single
That's the only way to do it, sir. There's no other way to do it. These things can't be changed by a court also. If the pass mark is 40%, the court can't say for you treat it as 30%. How can it be? Can't be. It's just not possible. And there's no estoppel in these things. There's absolutely no estoppel. I think this judgment will just follow the full bench, which you have unearthed. That full bench will answer the question.
My lord.
Only if it is not within your knowledge. It's within your knowledge. Your marks are shown to you. You see your English mark, you know you have failed, you appear for the compartmental. You're shown your education marks, you choose not to believe it. That's the problem.
And she has,
It is fail.
she has already completed class 3 and now she is in her matrimonial home, my lord. Dispute arose while her husband asked the appellant to produce the CHSC certificate, my lord. Then only she came to this honorable court, my lord. This is a real fact, my lord.
I know, but can't be helped, sir. If she sits for the exam, she passes it, she'll get the certificate.
And another judgment I would like to. Honorable Sam single judge, my lord. Allowing the repetition in a similar circumstance, my lord. Promissory estoppel would apply, my lord.
Is there already there? Single judge.
Already there.
Para
There,
25 and 26.
It is there.
Mm. 25 and 26.
That was because before cancellation, no notice was issued. That's a different issue. Here, there was no cancellation. Here, you are asking for a CHSE certificate to be issued.
They are not issued.
And they're not issuing. Slightly different facts. There, they cancelled his candidature. Cancel the result.
There are natural justice argument and everything is there. So
No
here-
prior notice was issued. First declare him pass and then declare him fail without notice. That's the point. Here, they never declared you pass. In fact, they didn't issue you a CHSE. Just come to your mark sheet also.
My lord.
Page 8. It's so clear, see.
The student will be reflected that she has failed in education. Nowhere it is reflected that she has failed in education, my lord.
Clearly indicated fail in capital letters.
With fail out. Another exam.
14, 21, 35 in English.
Oh, so after looking at this, he presumed only English is failed.
Yeah.
That's his mistake.
The 80
in education this. Yeah. Every student knows. Nobody is under any illusion on these things.
Then the while she got admitted in prostate examination, the principal.
So only thing you write an exam and pass.
Yes.
No other shortcut.
And the next page, Mela, page 9. Page 9. On the basis of which, my lord, she has prosecuted her high stories. Page 9.
They failed to detect. Actually,
40%.
You got undetected doesn't mean that you have not failed.
No, my lord. I cannot. I cannot.
Because the university, I think somehow they could not detect.
Yeah. She managed to get the single.
That's what I'm saying. They didn't check.
Matter.
Reserve. We pass the judgment.
Another judgment, I am just handing over to you.
All right.
directed the petitioner to prepare a log of all the calls made to all the hospitals and submit an affidavit. My lord, this is that PIL regarding organ donation.
Yeah, correct.
My lord, we've submitted the affidavit. We have served a copy on the government also.
No, another copy may be served because that copy is not available in my file. Let me check that affidavit.
My lord, they have received it on 22nd 2023. My lord, so we have the receipt also.
Okay, you give another.
Just give him another, no problem.
Okay.
This has to be attended to because.
But that is some private hospitals, according to him, they are not responding.
No, so you have to because they are after all on your panel.
That is why I am submitting. He has filed an application to implicate those hospitals as parties.
No,
Lordship may issue notice to them.
No, my lords. In fact, your lordships had directed on the last occasion that instead of impleading all the hospitals as parties, it is better that you.
From your health department, if it goes, the call goes, then I mean. You can pull them up.
No. According to him, some calls have remained unattended by some private hospitals. And as the nodal agency, I can also call for explanation why this.
They're all people are being referred by you to also these private hospitals for these services.
No,
that's the whole
government. Vice versa is. They are referring to government hospitals.
No. For this act, this help desk for the purpose.
Yes, they are registered. They are registered for this act.
All these hospitals that we have gotten in touch with, they are all registered under the transplantation of human organs. And we have gotten in touch with all the premier hospitals across the city, my lords. And all the one thing which we observed from this entire exercise was that the transplant coordinators, none of the transplant coordinators are themselves aware of the procedure of organ donation and transplantation. That was what feedback they gave us when we got in touch with them. And this situation is exactly similar to the situation that prevailed at the time of the death of the relative of the petitioner number 2, which was why he was compelled to file this PIL, my lords. So they expect us at a sensitive point of time when our relative or friend or near ones, we have lost them at that point of time. So they are asking us to go and get in touch with this particular member of this ward and that hospital and this. They're delegating their responsibilities, my lords. So what is the purpose of them being there as transplant coordinators if they are not able to guide us properly at a sensitive time at that point of time?
My lord, can I submit one? Why I humbly submit that those institutions should be noticed because once they get notice from this honorable court and they will be aware of the situation and all these allegations of the petitioner, instead of giving notice from the government agency, if they get notice from the court, that they will be more serious. That is my respectful submission. And it is
the point is
there are only 10 to 12 institutions. Let him notice all of them. Let them come, and so that whatever order will be passed, that will be directly binding on them. All are premium institutions.
My lord, that will be a cumbersome procedure, my lord. That is the reason why your lordship.
Effective adjudication, you are a PIL petitioner. You should opt for an effective adjudication of the matter.
No, I think the first instance you contact them. You say an affidavit has been filed by the petitioner on 22nd February 2023, giving details of the calls made to 5 of the hospitals in Bhubaneswar, is it? And Cuttack.
All are of Bhubaneswar.
In Bhubaneswar, where either no response is forthcoming or an inadequate response was received when the helpline was called. Paragraph. Mr. D.K. Manthil at AGA suggests that this court should issue notice to each of those hospitals to call for an explanation. Stop. Before doing so, the court would like the health department of the government of Odisha to contact the key person in each of these hospitals to convey the concern of the court by furnishing them with a copy of the affidavit filed by the petitioner and to instruct them to strictly comply with the requirements of the Transplantation of Human Organs and Tissues Act 1994, and more importantly, for their, what do they call them, nodal officers?
Well,
What is that officer that under the act? Which officer?
transplant
State organ
And for the transplant coordinator in each of the hospitals to be fully oriented to properly guide persons seeking relief under its provisions. Full stop. An affidavit of compliance will be filed by the senior level officer of the health department. Before that,
earlier affidavit was filed by the special secretary to government health. Anyway, senior level officer.
Officer of the health department. List on this again we'll have on the opening date, 21st June.
May I pray that this order may be communicated by the registry to the Secretary Health and Family Welfare.
Okay. The registry will communicate this order forthwith to the Secretary Health and Family Welfare Department.
Item number 54.
Gratefully.
I may be pardoned, my lord. I'm in virtual mail. I'm with the petitioner. But since the last direction was since the date 2014, there is no counter filed as yet.
Yes, my lord. I have received the instruction today, my lord, only. I pray, my lord, only 1 week time to file counter after in this case.
So this is a 2014 matter.
Yes, my lord. My lord, on the last occasion, I entered appearance and also I received the instruction today itself.
Can't. What's the matter about, sir?
My lord, the property was purchased by the petitioner, a lady of 65 years old then, in the year 1982. She is in possession of the property and constructed a building thereon and staying. And the department against the vendor was one Gopal Agarwal. There was an assessment demand sometimes in 85, 86. And that demand was issued to them in 86. So suddenly, they issued a notice that Annexure 6 for attachment of the property and directing the petitioner to vacate the house. So the point of law here, my lord, this rule 68B of the schedule, second schedule, demarcates the outline saying that any attached property, 68B of the IT law, saying that no sale of movable properties shall be made under this part after the expiry of 3 years from the end of financial year in which the order giving rise to a demand of any tax, interest and penalty or any other sum for recovery of which removed property has been attached. My lord, here in this case, the property was shown attached in year 1986. And my lord, the law underwent amendment in 92. And now they are issuing this notice, Annexure 6, in 2014. That's the only point of law. But there are earlier, my lord.
1 minute, you were reading section 68B, is it?
68B, my lord. Rule 16. Schedule 2. Schedule 2, my lord.
You're not telling us whether it's rules or act.
Rule, my lord. Schedule 2, my lord. Schedule 2, italic 2, my lord. 68B. I have quoted also.
We're just trying to see where this is from. There are appendix. Now there is. Only talks of appendices, sir.
Sir, appendix.
This is the latest book.
Rule 68B, Schedule 2. It is part 3. Part 3. Part 3 deals with attachment and sale of immovable property. Part 3, man. Starts with Rule 48, attachment. Part 3 starts with attachment and sale of immovable property and starts with Rule 48, and relevant challenge provision is 68B.
Mr. Mahapatra, do you have the book?
My lord, yes.
Do you have the book?
No, my lord. I have only act.
We have the 59th edition, 2022. I don't know which edition you are referring to.
I am referring to, my lord, 2014 edition.
Ah, no wonder.
My lord.
We have a 2022 edition, sir.
My lord. My lord, part cannot be changed with a measure chapter. Part 3 is exclusively dealing with attachment and sale of immovable property.
Part 3 now is assessment procedure.
My lord, the second schedule deals with procedure for recovery of tax. That is the second schedule, procedure for recovery
There are no
of tax.
schedules, sir. The
My lord,
present
schedule.
book does not have any schedules.
But then when I filed the case, it was with schedule. So, lordship, may fix a date. I'll come with this book and all that.
All right. So, Mr. Mahapatra states that the counter will be possibly filed within 2 weeks. You joined up with the next date.
Interim to continue, my lord.
Interim order to continue. List on 5th September.
Okay. Item 55.
55, my lords. Mr. Mishra was appearing in this matter, my lords. There's a noting that this appearance of Mr. Satyajit Mahanti not yet received. We have filed today, my lords. And so far as the matter is concerned, my lords, it is with regard to the assessment order under Section 10 of the Anti-Tax Act. And it is covered under my lords' ICMA's judgment, my lords.
Yes, last time you clearly said in the order itself. Just read this. Para 2. Right? And just see the appearance to this. Again, see a chess section. Say in place of it should have been struck out. Do it now, sir. And please instruct them.
Mr. Mishra's name may be deleted, my lords.
We have already said, sir. I've already told them again to delete. They've already shown Mr. Navanti's name now. Today's list. Yes. All right. It's covered by ICMAS, is it?
My lords.
My lord, as regards ICMAS, we have filed the SLP.
No stay, no?
No stay.
That's fine. In view of the decision in ICMAS Resins, Private Limited State of Orissa, 2022 to ILR Cuttack 817. The impugned assessment order and the consequent demands are hereby quashed. The writ petition is disposed of in the waters.
Item 56.
56, my lords. The connected VAT matter is, my lords, has placed a fixed on 5th July. This is
all right. List on 5th July. All right.
My lords, Mr. Mishra's name may be deleted.
Item 57.
Please, Your Lordship.
Yes,
Your Lordship, Your Lordship, I am appearing through online mode. Your Lordship, during the course of last hearing, you directed respondent to file the counter affidavit. And Your Lordship, we have received the counter affidavit and they are ready to drop the reassessment under 148, Your Lordship. Just a humble request, Your Lordship. We have checked the income tax portal and found that the reassessment has not yet been dropped by them.
Now they will drop it. Now in the counter
Lord,
affidavit filed with the department, it is stated that the department is prepared to drop the proceedings under section 148 of the Act for FY 1999-2000.
Lord, 1314. Your Lordship.
1314. AY 1314.
Yes.
In that view of the matter, taking the statement on record, the petition is disposed of. The corresponding portal, the web portal should reflect this decision of the department forthwith. All right.
Obliged, Your Lordship. Highly obliged.
Item number 58.
Your Lordship, Annexure 1, page 8, my lord. The list of demand has been raised by the opposite parties, but there is no service of a notice, nothing of the sort. But Your Lordship, in the preceding occasion, that 1/12/2020 directed them to furnish affidavit and the details of the record, revised record is that demand stand at 49 lakh.
He's replied.
Those are there, my lord, but my lord would see it's a VAT notice. In fact, the problem is in this attachment notice, we have also mentioned about the demands under OST. So, my lord, I have taken instruction. We are withdrawing this notice. So, it's to issue appropriate notice individually under the separate acts, my lord.
All right. Counsel for the Mr. Paddy, learned counsel for the department on instruction states that the impugn notices are being withdrawn.
Notice under Annexure 1.
Bracket Annexure 1 is being withdrawn and fresh notices will be issued in accordance with law, stating the separate demands under the different statutes. So in view of the above statement, the writ petition is disposed of. It will be open to the petitioner to question the fresh demands in accordance with law.
In the meantime, attachment will be vacated.
Yeah, the attachment is vacated.
Issued by the department.
May I pray, I have been given 10 days because in the meantime, the whole purpose will be frustrated.
No, why keep the attachment? No
but for 10 days at least.
No, not necessary, sir. Not necessary. Yes.
Item 59.
What's in this matter, on the last occasion, my learned friend was directed to file a counter.
5960, my lord. I have received the instruction, my lord.
Last opportunity to the department to file its reply within 8 weeks, rejoined up for the next date. Interim orders to continue. List on 14 September.
59 and 60.
In both the matters.
Yeah.
Interim order in both the matters.
Item 61.
Interim order
in both the matters.
Item number 61.
Challenge the action of the Deputy Commissioner in adjusting the refund under the GST when admittedly corporate insurance proceeding is continuing and moratorium has already been promulgated by the NCLT.
My lord, here I seek some more time to file the reply, my lord.
It's before the NCLT.
No, my lord, insolvency was, it didn't, CIRP has failed, so it has gone into liquidation. In liquidation, it's all open, my lord. I'll file a detailed counter, my lord. Give me 1 week time to file counter.
Liquidation is open? I don't understand. What does it mean? Sorry.
My lord, the pending proceedings can continue during the liquidation proceeding.
During the insolvency proceeding, they have adjusted the amount. That is the case, my lord.
My lord.
Anyway, let it moratorium was continuing. To file a reply within 8 weeks, rejoined up for the next date. Is there an interim order? No.
Recover.
List on 14 September. All right. Same both 61, 69. Yeah.
Item 63.
Well, 63, my lord, similar matter has been fixed to my lord, 18th July.
Council already filed, my lord. I am for the opinion number 3 and 5, State Pollution Control Board.
Other matters, the lordships have passed this order last week.
Item number 65.
65 just now served the counter, Lord. With regard to this grant of on license has been rejected. Just now he has served the copy of the counter, Lord.
All right. Rejoined file for the next date.
Any date before 31st, Lord. 25th, 26th, Lordship. 27th, Lord.
29th.
Okay.
All right, 29th March, interim order to continue.
Yes. Published.
Interim
Item
order?
six-
There is no interim order, I think. What interim order?
No course event.
Item 66.
Already, my lord, in that case, the government has already rejected. Then what is no coercive order?
Already last.
But rejected, then that's the end of the matter.
That interim order has no.
That's the question. If the rejected means I didn't know that.
Finally, they have rejected.
Oh, I see.
No. Lordship is.
No. What is
But the Lordship said directed last. Last week, last
What
week.
is the
Only for them to pass the
proposal
order.
is rejected. Then what is the
Item 65, you say, with the government having rejected the application of the petitioner, no further directions are needed as far as the present petition is concerned.
Lord.
The petition is disposed of, the interim order is vacated. All right.
Item number 66.
66, my lord, while issuing notice, your lordship has specifically fixed today, but no counter attacks come from the government.
Within 1 week, I will file the count.
Lordship, the whole
Again, same issue.
Same issue,
On
31st
March.
9th,
So-
Lordship may fix it to 9th. 9th, it will be taken up for.
All right. List on 9th, counter by be filed by 6th. All right.
obliged, my lord.
Item number 67.
Lord, the government has rejected the proposal for on-sub license primarily on the ground that the collector and commissioner have not given any special circumstances for which the distance criteria can be relaxed.
You can challenge that, sir.
Lord, government has already rejected it. What I am trying to tell your lordship may kindly permit me, because this is not the requirement of law. I'll reapproach the government to consider my case.
This petition is over, sir. If you approach, we don't have to give you permission.
No, in fact, in view of the order, if your lordship see page 18, this is not the requirement of law. Government do not require any recommendation from the
No, then
collector.
you have to again challenge that by filing.
I'm challenging here before your lordship.
No. Not orally. Now, only now the order has been passed.
No, this is the order challenge before your lordship.
The government order is challenged.
Government's order is under challenge.
Government's order.
Okay.
But government's order is under challenge. If your lordship see page 18, the government has rejected my proposal saying that the collector and commissioner have not given any special circumstances on which there can be relaxation.
How is it listed today? Because it's 15.
But I on my mention, because the 31st of March is fast approaching, and my application, if at all, can be considered, let them. Well, I'll approach the government to reconsider the matter if they can do it.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the government again to reconsider its decision. The petition is disposed of with liberty is prayed for.
Yes.
All right.
Item number 68.
68, on behalf of the state, Mr. Khuntia will do it. I seek some adjournment.
All right. List on, at the request of counsel of the parties, list on 27 September.
Item 69.
My lord, on behalf of Mr. Mahanti's father is expired. May kindly.
Counsel for the petitioner is stated to be in some personal difficulty. List on 26 September.
Item number 70.
My pleasure, Lords.
Item 70, I'm appearing for the respondent number 6. In fact. It's a writ appeal filed by my learned friend on behalf of his client, challenging the order passed by the Honorable Single Judge. Would I request your lordship to take up the matter sometime in the month of April?
No, some negotiation was in process. What happened?
My lord, the parties are not conversing. My lord, may kindly turn to the order dated 30th January.
Right.
May I place that order?
In fact, I'm trying for that. If my learned friend agrees further, that's the reason I'm asking for time. But trying to
Parties are in fact not converging. If my learned senior agrees for an arbitration, let it be a formal in nature. If he agrees for an arbitration, authorized parties are on conciliation, they are not converging. And the learned honorable court has expressed already in this order, my lord. So
what I'm trying to tell is it's a family trust among the brothers. Their dispute arose between themselves. As your lordship knows, money is the source of all dispute. So let me again have a trial. If good sense prevails, they can settle down, because a suit was filed that is dismissed for default. Appeal is pending here.
So this advancing the date of hearing, you filed the IA, sir?
My learned,
no,
Mr. Learned senior counsel Vidyut Praptray, but the respondent number 1 has filed.
And they are not there to proceed.
Anyway,
In
this
fact, that is also all over, because in January that was filed. prior to 30th January. That
All
was-
right. You see this application 81 of 2023, with the matter having been listed today, the application has become infructuous, is disposed of. And then in the main writ appeal, you say Mr. P.K. Rathore, learned counsel, appearing for
Respondent number 6, madam.
Respondent number 6 states that efforts will be made to arrive at a negotiated settlement and prays for some time.
Play only a short date, my lord, my kind.
Sometime April, my lord.
4th April.
4th April, yes.
1 month.
Obliged. Interim order to continue.
Interim order to continue. Huh?
Yes.
Where we shown in the cost list. All right.
Pastor matter item number 3.
I apologize, my lord. My senior could not appear in BC, and I pray for liberty to approach the appellate.
That's what. Counsel petitioner seeks leave to withdraw the present petition with liberty to approach the appellate authority in accordance with law if such appeal is filed not later than 20th April, accompanied by an application for continuation of delay, then to be considered in accordance with law. Usual thing. My lord. The court clarifies it has not expressed any view in the matter. The originals be returned subject to being substituted with attested photocopies. Over. All right.